सर हेलो सर मलाई सर त्यो यो ल्यान्ड रेभेन्यूको विषयमा अलिकति मैले केही भन्नुपर्दा एक्सपिरियन्सको विषयमा अब मैले भन्नुपर्दाखेरि अब डिस्प्युट अफ ल्यान्ड केस छ भने अब त्यो कसरी गर्छ भन्ने कुरो अब यो विषयमा मलाई अलिकति भनिदिनु भन्दाखेरि म यहाँ तपाईँको अगाडि आएको छु र कुनै पनि ठाउँमा एउटा जमिनको झमेला भयो भनेदेखि हामी त्यो ठाउँमा अब उहाँहरूलाई डिसिजन दिनु जाँदाखेरि त्यो एक्ज्याक्ट झमेला भएको एरियाको लोकेसन डिमार्केट गर्नुभन्दा अगाडि चाहिँ हामीले एउटा एक्ज्याक्ट पोइन्ट लिनु लागि चाहिँ एउटा कुनै पनि त्यो ठाउँको के भन्छ त्यसलाई फिक्स पोइन्ट लिनु लागि चाहिँ कुनै पनि स्ट्रक्चर या त खोला खोल्चा झोडा या त 3 सिमाना कसैको जमिन छ भने त्यो हामीले बेस गर्नुपर्छ। त्यसकारणले गर्दा त्यो ठाउँमा हामीले आफ्नो खुसीले त्यो म्यापको डेटिङ गरेर म्यापलाई लिएर चाहिँ हामी रिडिङ लिनु पनि सक्दैनौँ किनभने मान्छे चाहियो। त्यहाँको बााउन्ड्री होल्डर सीमानदार मान्छेको उपस्थितिमा हामीले सोध्छौँ र हामीले यो त्यो तय गरेपछि त्यहाँदेखि हामी त्यो डिस्प्युट भएको केसलाई डिमार्केट गरेर देखाउँदाखेरि अब कतिले भन्छ यो होइन त्यो भन्छ। त्यसले गर्दा अर्को पोइन्टबाट नि हामी उहाँलाई त्यो पोइन्ट चाहिँ अब त्यो डिस्प्युट भएको पोइन्टमा चाहिँ उनीहरूलाई चाहिँ डिसाइड भएन भने सेटिस्फाई भएन भने अर्को पोइन्ट पनि लिएर त्यो पोइन्टमा हामी डाइरेक्सन देखाएर चाहिँ त्यो डाइरेक्सन त्यो पोइन्टमा लगेर त्यो जुन चाहिँ केस भएको अथवा सेटिस्फाई नभएको स्पटलाई चाहिँ हामी क्लियरिफाई गर्छौँ। त्यसरी नै अब बााउन्ड्री त्यो बााउन्ड्रीमा चाहिँ अब 3 सिमाना हामीले त्यो बााउन्ड्री तय भएन भने हामीले कुनै पनि एउटा स्ट्रक्चर कहीँ पनि एउटा घरको एउटा इन्डिकेट गरेको नक्सा छ भने त्यो नक्सालाई हामीले पेश गरेर त्यो नक्सा अनुसार पनि ल्याएर हामीले त्यो देखाइदिन्छौँ। त्यो पनि मान्नु भएन भने अब त्यहाँदेखि के हुन्छ भने अर्को कुरो त्यो पार्टिकुलर प्लटलाई चाहिँ अब यो रङ छ भनेर भन्छ भने त्यो चाहिँ अब उहाँहरूकै उयो हो पब्लिकको अब एकदमै के डिनाइ हो त्यो नक्सालाई मान्दैन कतिले। त्यसले गर्दा मान्नु या नमान्नु हामी चाहिँ यो नक्साको आधारमा हामी चाहिँ डिमार्केट गरेर त्यो पोइन्टलाई एक्ज्याक्ट हामी त्यो चाहिँ देखाइदिन्छौँ। देखाएको अनुसार उहाँहरूले सेटिस्फाई भने उहाँहरू ठिकै छ मान्नुभयो एम्बिकेबल आएको आएन भने फर्दर उहाँहरू जान्छ कोर्टमै। त्यसले गर्दा चाहिँ कोर्टले रातमा डिसिसन दिन्छ र रिपोर्ट हामी त्यही अनुसार हामी त्यो दिन्छौँ। त्यो छ सर। अर्को कुरो अब हाम्रो अब रेकर्ड खसरा खतियान भन्ने कुरो छ। खसरा खतियान अब एउटा रेभेन्यू ब्लक सर्वे गऱ्यो भने सर्वे सकिएपछि रेभेन्यू ब्लक एउटा कन्सर्न अमिले सर्वे गर्ने हो। त्यसको बादमा चेक दिने बेला बेलामा आएर त्यो रङ अब सर्वे ठिक छ छैन भन्ने कुरो चाहिँ रेभेन्यू आरो सबबाट आएर त्यहाँ देख्छ हेर्छ र त्यो मुनि खटाएको हुन्छ हेड अमिन र इन्सपेक्टर हुन्छ र त्यो पार्ट अफ अब त्यो रेभेन्यू ब्लक चाहिँ सर्वे गर्छ आदिविधि सकेको छ भने त्यो ठिक छ ठिक भयो भएन भन्ने कुरो हेड सर्वेयर इन्सपेक्टर गएर उहाँहरूले त्यो रेभेन्यू ब्लकमा जति सर्वे भएको छ त्यो उहाँहरूले चेक गर्नुहुन्छ। चेक गर्दाखेरि अब कहीँ ल्याटिट्युड लङ्गिट्युड हुन्छ हाइट हुन्छ त्यो अनुसार अब कहीँ बद हुँदैछ अब बााउन्ड्री मिलेको छैन अब कसैको सिमाना मिलेको छैन भने उहाँहरूले फेरि त्यो कुरोलाई चाहिँ ब्याक गरेर उहाँहरूले सर्वे गरेर चाहिँ उहाँहरूसँगै त्यो 3 जना बसेर सर्वे गरेर चाहिँ त्यो पोइन्टहरू उहाँहरूले वर्कआउट गर्नुहुन्छ। त्यो अब सकिएपछि त्यो ब्लक सक्यो ठिक छ त्यो सबै ओके भयो भने अब रेकर्ड राइटिङ कुरा आउँछ। रेकर्ड राइटिङ त्यति हुँदैन प्लटिङको कुरा आउँछ। रेभेन्यू ब्लक अब हामीले सक्यो सर्वे गरेर भनेपछि उहाँहरूले खबर गर्छु हेड अमिन जान्छ उहाँ हेड अमिनले गएर हेर्छ हेरेर आएर रेभेन्यू ब्लक उहाँहरूले चाहिँ सर्वेले वर्कआउट गरिसकेछ म सर्वे गरिसकेछ त्यसलाई रेकर्ड राइटिङ अब गर्नु लागि के गर्नु भनेर चाहिँ माग्दाखेरि प्लटिङको कुरा आउँछ। प्लटिङ गर्नुभन्दा अगाडि त्यो फिल्डमा अब उहाँले गरेको अनुसार नक्सा अब फिल्ड बुक हुन्छ फिल्ड बुक अनुसार उहाँहरूले त्यो रेकर्ड अब सर्वे गरिसकेपछि उहाँहरूले त्यो देखाएको हुन्छ उहाँहरूले गएर रेभेन्यू अफसरलाई रिपोर्ट गरेको हुन्छ। उहाँहरूले जुन सर्वे गरेको रिपोर्ट सकेछ मतलब सर्वे गरेको ब्लक सक्यो। अब यो के गर्नुपर्छ भन्दाखेरि अब रेकर्ड राइटिङ पुरा रेकर्ड राइटिङ गर्नुभन्दा अगाडि चाहिँ वेस्टर्न र इस्टर्न मतलब वेस्टर्न र नर्दर्न साइडको साइडबाट प्लटिङ सुरु हुन्छ। प्लटिङ सुरु भएपछि जस्तै प्लटिङ सुरु भयो 1 नम्बर प्लटिङ अब सुरु गर्दाखेरि जस्तै सरकार आयो भने सरकार प्लट नम्बर 1 सरकार त्यस्तै खसरामा नि अब यो खसरा यस्तो छ खसरामा त्यसरी नै प्लटिङ हुन्छ। 1 नम्बर जस्तो सरकार यहाँ अब सरकार भनेपछि 1 नम्बर कसको आयो भन्दाखेरि यो ब्लक चाहिँ तपाईको साजुङको उता सेन्टर पार्टनर साजुङ। अब 1 नम्बर चाहिँ कसको आयो भने नर्दर्न र वेस्टर्न साइडको पोइन्टबाट चाहिँ सुरु हुन्छ रेकर्ड राइटिङ, प्लटिङ सुरु हुन्छ। प्लटिङ हुन्छ नै रेकर्ड राइटिङ सुरु हुन्छ। प्लट नम्बर 1 कसको आयो भन्दाखेरि जस्तै प्रभाकर छोरा, उसको बाबुको नाम चाहिँ राजभद्रको छेत्री ब्राह्मणको नाममा भएको त्यो भनेर जनाइन्छ। त्यसको डिस्क्रिप्सन यहाँ दिएको हुन्छ, सुक्खाबारी पानीखेत, त्यसको एरिया मेन्सन दिएको हुन्छ। रिमासमा के छ भने अब रिमास कलममा कुनै अध्यादार कुत्यादार कोही मान्छे बसेछ भने त्यो दिएको हुन्छ, अथवा छैन भने त्यहाँ उहाँको एउटा घर छ भने घर मकान भन्ने दिएको हुन्छ, अथवा सुन्तला बारी छ भने सुन्तला, अब कुनै पनि फलफुलको रुख छ भने त्यो जनाएको हुन्छ। त्यस्तै अब 2 नम्बर कसको थियो भन्दाखेरि धनमान गुरुङको जमिन आयो भने त्यहाँ पनि नर्दर्न त्यो वेस्टर्न साइडको प्लटिङबाट 2 नम्बर उसको। त्यसरी नै खसरा इन्डेक्स भन्दै खसरा यसरी बनिन्छ। खसरा यसरी बनिसकेपछि यो खसरा राइटिङ सकेपछि एरिया लेखेको हुँदैन, एरिया चाहिँ बादमा गरेको हुन्छ। एरियालाई चाहिँ बादमा अब के भन्छ त्यसलाई एरिया कम्लाएर 3 टाइम्ससम्म अब त्यो टाइममा उहिलेको अहिलेको त जिपिएस र इटिएसले कोअर्डिनेट गर्दै जाँदाखेरि तपाईँको टोटल स्टेसन दिएपछि एरिया पनि आइहाल्छ, बााउन्ड्री पनि देखाइहाल्छ। त्यसले गर्दा त्यो अब पहिलाको टेक्नोलोजी अब ट्रेन टेबल सर्भेमा चाहिँ पहिला सबै गरिसकेपछि त्यसको बाद मात्रै त्यहाँदेखि एरिया निकालेर लास्टमा एरिया दिन्छ। एरिया निकालेर एरिया दिएपछि एरिया निकालेपछि त्यहाँदेखि चाहिँ एउटा डुप्लिकेट पर्चा, एउटा फिल्ड कपी भन्छ, त्यो चाहिँ सर्भेयरले बस्तीवालालाई दिएको हुन्छ हातमा। त्यो चाहिँ एथेन्टिक हुँदैन खासमा, त्यो एउटा टेम्परेरी मात्रै दिएको हुन्छ। त्यसको बादमा एरिया निकालेर सबै कुरो कम्प्लिट भएपछि त्यहाँदेखि सबै चेक गरेर चाहिँ आरओ इन्सपेक्टर सबै भएर चेक गरेर क्रस चेक गरेर सबै रेकर्ड राइटिङ कम्प्लिट भएपछि त्यसको बादमा खतियान बनिन्छ। खतियान त्यो चाहिँ एकदम कम्प्लिटली बनाइसकेपछि अब यो खतियान हुन्छ। खतियानमा जस्तै एकजना जस्तै यो बलभद्रको जमिन भयो, त्यो मान्छेको त्यो इन्टायर ब्लकमा तल खोलाघाट छेउमा माथि बिचमा कहीँ पनि होस् उहाँको 10वटा प्लट छ भने 10वटा प्लटको उहाँले यहाँनिर यो खतियान बनिन्छ। त्यसलाई चाहिँ एरिया पनि मेन्सन गरेर एरिया सबै दिएको हुन्छ उहाँको। त्यो टाइममा चाहिँ त्यसलाई चाहिँ त्यो के गरेको हुन्छ, त्यो अब जति जमिन अब त्यो भएको चाहिँ उसको होल्डिङ कति आयो, अब त्यो ब्लकमा चाहिँ 10वटा प्लट छ भने 10वटा एरियाको त्यसको डिटेल्स दिएको हुन्छ। त्यसको डिटेल्स दिएपछि चाहिँ खतियान पर्चा उहाँको नाममा के भन्छ एटेस्टेसन अब गर्नुभन्दा अगाडि उहाँहरूलाई यो रेकर्डसँग कम्पाइल गर्नु लागि अब हाम्रो ठुलो अफसर अब आएर कन्सर्न एटेस्टेसन अफसर आएर चेक गरेर सबको चेक गरिसकेपछि यो पब्लिकको हातमा भएको पर्चा यहाँ भएको रेकर्डसँग कम्पाइल हुन्छ। त्यो आधारमा त्यहाँदेखि कम्प्लिट भएपछि मात्रै त्यसलाई रेक्टिफाई गर्नु छ भने गरिन्छ, अथवा कसैले चाहिँ अब अपोज गर्नुहुन्छ यो चाहिँ हामी मान्दैन भन्छ। त्यति बेला के भयो भन्दाखेरि त्यो केही कमिसन आएको के कमी हुन्छ, त्यसमा आउँदाखेरि त्यो कमी के हुँदाखेरि कसको चाहिँ अब आयो त्यो फेरि त्यसलाई चाहिँ पेन्डिङ राख्छ र त्यहाँ एउटा उहाँको दर्ता उहाँले एउटा एप्लिकेसन गरेको हुन्छ, त्यो पेन्डिङ राख्छ र बाँकीहरू सबै क्रस चेक गरेर सबै भएपछि उहाँहरूलाई पर्चा इस्यु हुन्छ। लास्टमा त्यो चाहिँ त्यही दिन दिँदैन, त्यो दिन त्यति हेरिङ हुन्छ, त्यो मतलब त्यसलाई नोटिस गराएको हुन्छ कन्सर्न एउटा गाउँको त्यति बेला मण्डल हुन्छ, मण्डललाई यो फल्ना दिन अब तपाईँहरूले आफ्नो गाउँ बस्तीवालालाई तपाईँको केही गुनासो के छ भने लिएर आउनु, यो त्यो दिन चाहिँ हामी यहाँ एटेस्टेसन गर्दैछ भनेर एटेस्टेसन अफिसरलाई अब त्यो चाहिँ मतलब एटेस्टेसन गरेर खानापुरी भन्छ त्यो टोटल त्यो रेकर्ड करेक्सन गर्ने कुरो गरेर कम्प्लिट गरेर त्यो दिने काम हुन्छ। त्यसको बादमा त्यो दिइसकेपछि अब कसैको अब त्यो जसले अब मानेको छैन त्यो नमान्ने मान्छेहरूको अब जस्तै त्यो एकपल्ट फेरि फिल्ड गर्नु पठाउँछ, कन्सर्न अमिन जान्छ, हेड सर्भे जान्छ, इन्सपेक्टर जान्छ, गएर हेरेर उहाँले फिल्ड गरेर मिल्यो भने त्यति बेला सेटल गरेर एउटा उहाँहरूको त्यो रेकर्ड राइटिङको बेलामै गरेर उहाँहरूलाई त्यो रेकर्डहरू दिइहाल्छ। मतलब मिल्यो भने उनीहरूको एउटा क्लियरिफिकेसन लिएर क्लियरिफिकेसन उनीहरूको लिएर चाहिँ हामीले त्यो एउटा पर्चा पनि त्यही मिलाएर दिन्छ। मानेन भने फर्दर त्यो चाहिँ केसै हुन्छ, पछि त्यो कोर्टमा जान्छ। त्यसरी नै हाम्रो चाहिँ यो रेकर्डको विषयमा चाहिँ यस्तो छ, मेरो एक्सपिरियन्स यति नै छ हो। कहीँ के भयो भने चाहिँ सर अलिक बुझेन भनिदिनुहोस्। डिमार्केसन कुरो हो त्यो चाहिँ, रेकर्ड राइटिङ कुरा चाहिँ यस्तो हो सर। अब यो फिल्ड गर्दा चाहिँ आफ्नो खुसीले गएर चाहिँ कसैको जमिन नाप्न जाँदाखेरि कसैको फिल्ड गर्नु गयो, केही डिस्प्युट छ भने आफ्नो खुसीले गएर चाहिँ खट्टा गर्न सक्दैन, किनभने कन्सर्न ल्यान्ड ओनर हुनु पऱ्यो, जो एप्लाई गर्ने मान्छे हुनु पऱ्यो, र कन्सर्न अब त्यो गाउँको एउटा डिजिपी भने अब त्यति बेला पहिला मण्डल हुन्थ्यो अल एन्ड अल, अहिले चाहिँ पञ्चायत छ। पञ्चायतलाई इन्भल्भ गराएर हामी त्यो स्पट मौकामा जाँदा चाहिँ त्यो एउटा एक्ज्याक्ट पोइन्ट लिनु लागि बााउन्ड्री होल्डर सीमान्दार राखेर मात्रै हामी डिमार्केसन गर्छौँ। अदरवाइज हामी त्यो एकदम पार्टी आएन लु भनेको छ भने यति फाट्टै नाप्नु सक्दैन। कतिले गर्छ त्यस्तो, त्यो चाहिँ मिस्टेक हो। हाम्रो स्टाफहरू छ त्यस्तो गरी, अब हामी चाहिँ त्यो चाहिँ मान्दैनौँ। त्यसलाई चाहिँ कन्सर्न आफ्नो जुन प्रपर्टी होल्डिङ छ जसको छ उनीहरूकै उपस्थितिमा राखेर उनीहरूले नि भन्नु पऱ्यो मेरो हाम्रो सीमा यो हो, उहाँको भन्छ यो पोइन्ट। त्यो पोइन्टबाट नापेर लाँदाखेरि जस्तै उहाँको जमिन यति आउनुपर्ने, मेरो यति हो जमिन, मेरो यति फिट उहाँले चाहिँ अक्वाई गऱ्यो भने भन्छ, त्यसो हुन्छ। तर त्यस्तै अब त्यो छ भने चाहिँ त्यो पोइन्टबाट नापेर चाहिँ हामी त्यो देखाइदिन्छौँ, यो तपाईँको सीमा यहाँसम्म आउँछ भनेर। उहाँले भन्छ होइन यो त होइन मिस्टेक भयो। त्यसलाई उहाँले चाहिँ भन्नुभयो अब नक्सालाई बद गऱ्यो नि त। हामीले काम गरेको चाहिँ ऊ माथि हामी माथि गर्छ भएन, ठिकै छ। त्यो भने अर्को पोइन्टबाट फेरि ठिकै छ, त्यो पोइन्टबाट अर्को पोइन्टबाट हेरेर मिलाएर अर्काको सिमाना अरू हुन्छ, उहाँहरूको सिमानाबाट नापेर ल्याएर देखाइदिन्छौँ। र उहाँहरूको सिमाना दुईवटा अघि यहाँबाट देखाएको कहाँ छ, उहाँबाट आएको कहाँ छ, र कति डिफ्रेन्ट आयो। त्यसलाई अब त्यसमा अब कति मिलेन भने त्यो चाहिँ अब फिल्डमा अलिकति मिलाउने कुरो पनि हुन्छ। मिलाउने पक्षमा जाँदाखेरि चाहिँ एमिकेबल, अब 10 फिटको कुरा हामीले 5 फिटमा बसौँ भन्यो भने त्यो मान्यो भने ठिकै छ, मानेन भने अब केसै हुन्छ उनीहरूको त्यस्तो हुन्छ सर। फिल्ड गर्दा चाहिँ त्यसरी गरिन्छ, एक्ज्याक्ट लोकेसन छुट्याउनु लागि चाहिँ। मेरो एक्सपिरियन्स यति नै सर।
मैले सर एकछिन सर यताबाट बोकेको
यस सर।
अलिकति यो 1950-51 को जुन चाहिँ ओल्ड रेकर्ड छ नि,
हजुर।
अब सिक्किममा सर्भिस सेटलमेन्ट भयो 1979-80,
हजुर।
तर अब 1950 को ओल्ड रेकर्ड बाइफर्केट गरेर प्लट नम्बर कतिवटा मिलेर 7 छ।
हजुर।
सपोज कुनै पनि पोर्सन हरायो भने
52 को बेसमा सर,
52 देखि 1979-80 मा म्याक्सिमम सार्दाखेरि चाहिँ कतिवटा एरियाहरू मिल्दैन, किनभने कतिवटा कुरा भन्दाखेरि एउटा त कुरा एकरमा थियो।
हजुर।
1979 हेक्टरमा भयो।
हजुर।
अब यो पोर्सन जब मिलेन, यो जुन चाहिँ सर्भिस सेटलमेन्ट गर्दाखेरि चाहिँ खास गरी चाहिँ वास्तविकमा त्यति बेला अब राजाकै पालामा भनौँ,
हजुर,
अथोरिटी थियो। तर 1979 मा त प्रजातन्त्र आयो होइन।
हजुर।
र को चाहिँ अथोरिटी फिल्डमा हुनुपर्ने थियो, हुन्थ्यो, र उहाँले गरेको सर्भिस सेटलमेन्ट बाँकैमा करेक्ट थियो, जेन्युन थियो वा गल्ती थियो। बेसिक फिल्डमा चाहिँ को अथोरिटी हुनुपर्ने थियो सर्वे सेटलमेन्ट गर्दाखेरि, एउटा कुरा। सेकेन्ड कुरा, अहिले पनि तपाईँको कुरा गर्नुहुँदैछ फिल्डमा भन्नुहुँदैछ, यहाँ रुलले भन्छ ग्राम पञ्चायतको मेम्बर पनि हुनुपर्ने थियो भन्दैछ। तर प्र्याक्टिकली मेरो पनि अनुभव छ, उहाँ त आउनु हुँदैन, ग्राम पञ्चायत त आउँदैन। र फेरि अर्को कुरा के छ भनेदेखिलाई चाहिँ मेरो फर्स्ट क्वेसन चाहिँ 1950-52 को जुन चाहिँ रेकर्ड छ, हुनु त तपाईँहरूले गभर्मेन्टले सिज भनेर नोटिफिकेसन निकाल्नु भएको छ। तर अब अहिले हामीले हिस्ट्री सर्च रिपोर्ट गरेर हिस्ट्री कटाउँदाखेरि त्यो पनि चाहिने रहेछ रेकर्ड। यो सार्दाखेरि 1979-80 मा जब कुनै पनि एरियाहरू मिसप्लेस भयो भने त्यसको के सल्युसन छ, कोर्टमा डिस्प्युट आयो भने तपाईँ के सजेसन दिनुहुन्छ कि के हेर्दाखेरि ठिक हुन्छ, एउटा कुरा। अर्को कुरा, जब फिल्डमा तपाईँहरूले भेरिफिकेसन गर्नु जानुभयो, स्पट भेरिफिकेसन, के डकुमेन्टको आधारमा तपाईँले यति बेच्यो यति किन्यो भनेर हेर्नुहुन्छ कि मौखिक आधारमा गर्नुहुन्छ कि कुन चाहिँ? जस्तै फर इक्जाम्पल तपाईँलाई म सुझाव दिन्छु, धन रसिद र राजीनामा हुन्छ होइन?
हजुर।
यो डकुमेन्ट हेर्नुपर्छ कि के डकुमेन्ट हेरेर तपाईँहरूले सेल ट्रान्जेक्सन डिमार्केसन गर्नुहुन्छ?
त्यो पहिला सर 52 को रेकर्डको कुरा है सर। अब सिज भएको रेकर्ड भन्ने कुरा छ सर। सिज त अब भयो सर 1984 जब 1980 को रेकर्ड इम्पोज भएर 84 मा अब सिज भयो भने चाहिँ एउटा नोटिफिकेसन निस्क्यो। तैपनि फेरि पनि अब यो रेकर्डै सिज त भएको होइन, तर अब यो 1980 रेकर्ड अब 1980 को रेकर्ड चाहिँ अब युज हुन थाल्यो, तर अब यो पुरानो चाहिँ अब नचल्नु भन्ने कुरो खासमा बुझ्दाखेरि सर। तर पनि अहिले यही कुरोहरू अब चाहिन्छ सर। त्यस कारणले गर्दाखेरि अब 1984 मा त्यो सिज भएको नोटिफिकेसन त निस्क्यो सर, तर त्यो चाहिँ प्रपर गान्तोक एरिया भयो, चाङबारी भयो, अप्पर बुर्तुक, अप्पर सिचे, पाइनो रिजर्भ, यो चाहिँ जम्मै ओल्ड रेकर्डमै चल्छ सर।
अच्छा,
यो चाहिँ यो देउराली भयो, सब ओल्ड रेकर्डमै चल्छ सर जम्मै। किनभने 1980 मा यो सर्वे भएन।
अच्छा,
ओल्ड रेकर्ड यो अप्पर तालमसी यो गुरुद्वारा यो एरिया भेटनेरी भएको यो एरिया सबै ओल्ड रेकर्डमै चल्छ। त अब 50-52 को रेकर्ड अनुसार चाहिँ अब त्यो सर्टेन एरिया मिसिङ उहाँहरूको प्राइभेट ल्यान्ड छ सर, उहिले उसमा आएको छ। तर 1980 मा उहाँहरूको जमिन धेरै नै कम्ती भएको भने कहीँ सेल ट्रान्जेक्सन केही छ होला होइन, त्यो भएर कम्ती भयो भन्ने अब खोज्यो, त्यस्तो छ सर। तर अब त्यो अब कसरी कम्ती भयो भन्दाखेरि त्यही हो सर, अब कतिले चाहिँ अब क्यास रिसिभ अब धन रसिद बनाएर बेचेको हुन्छ। 1980 मा अब रेजिस्ट्रेसन नगरिकन त्यसलाई चाहिँ रेगुलाइज गरेर उहाँहरूले यो मैले चाहिँ बेचेको भनेर चाहिँ उनीहरूको नाममा रेगुलाइज भयो भनेदेखि 1980 मा 52 को रेकर्ड अनुसार कम्ती भएर गयो भने त्यो एउटा राजीनामा कागज हेरेर हुन्छ सर। फेरि एक त के हुन्छ अब जमिन चाहिँ एकअर्कामा मिसम्याच भएको छ भने 52 को रेकर्ड अनुसार दुईटै रेकर्डलाई लगेर फिल्ड गरेर चाहिँ डिमार्केट गरेर चाहिँ सर्टेन एरिया हराएको छ भने त्यो कुन चाहिँ प्लटबाट अब रि नम्बर 1980 को रि नम्बर जस्तै 201 अरे, 52 मा चाहिँ 500 छ अरे सर, अथवा 49 प्लट छ अरे भने त्यो 49 र त्यसको करस्पोन्डेन्स कुन चाहिँ हो भन्दाखेरि 201 अरे सर। अहिले त्यसमा चाहिँ अब एरिया कति छ भन्दा एरिया यसमा बेसी आएको छ भने र त्यो आउनुपर्ने त्यो पहिला चाहिँ फेरि त्यो चाहिँ कसको थियो भन्दाखेरि मनबहादुर थियो सर। मनबहादुरको जमिन त्यो करस्पोन्डेन्स कति थियो भन्दाखेरि त्यो टाइममा फेरि उसको चाहिँ अब त्यसमा चाहिँ त्यो अब प्लट नम्बर चाहिँ अब एडजोइनिङ बााउन्ड्रीमा चाहिँ अब 50 थियो सर। 50 को प्लट चाहिँ अब उसको 50 नम्बरमा चाहिँ 201 को एकमा चाहिँ मर्ज भएर गएर जाँदाखेरि 49 नम्बर प्लटको चाहिँ एरिया अब ओभरल्यापिङ भएर चाहिँ उसको नाममा गएको छ भने त्यसरी हामी फिल्ड गरेर चाहिँ दुईटै रेकर्डको बेस गरेर चाहिँ फिल्ड गर्दा चाहिँ वर्कआउट गरेर चाहिँ उहाँको कति डेसिमल गएको छ के गएको छ त्यो निकाल्छु सर। त्यस्तो छ सर।
यो करस्पोन्डिङ जुन चाहिँ प्लट छ नि केको आधारमा तपाईँहरूले दिनुहुन्छ? किनभने 1950-52 को जुन चाहिँ प्लट नम्बर छ
हजुर, अनि
हामीले भन्नुपर्छ हाम्रो कोर्टको ल्याङ्ग्वेजमा करस्पोन्डिङ प्लट नम्बर हजुर, तर त्यो करस्पोन्डिङ प्लट नम्बर चाहिँ कसरी आइडेन्टिफाई गर्छ र कसरी दिन्छ त्यो चाहिँ?
त्यो त्यही त सर, यो चाहिँ एउटा टेक्निकल रिपोर्ट छ, टेक्निकल अब काम हो सर। हामीले अफिसमा यहाँ हेरेर चाहिँ हामी यो यसको प्लट चाहिँ यो करस्पोन्डिङ न्यू प्लट यो भनेर भन्न सक्दैन सर। त्यसले गर्दा हामी फिल्डमै जानुपर्छ। फिल्डमै गएर 7980 को रेकर्डसँग कम्पाइल गर्दा कुन चाहिँ प्लट आउँछ, 52 लाई कुन चाहिँ बेस गर्छ र फिल्ड गर्दा चाहिँ फिल्डमा गएपछि त्यो मौका पुगेपछि चाहिँ 50 नम्बर प्लटको चाहिँ 49 नम्बर प्लटको चाहिँ 201 मा चाहिँ परेछ भनेपछि त्यो चाहिँ नम्बर चाहिँ 7980 को रेकर्ड 201 रहेछ भनेपछि त्यो प्लट चाहिँ मर्ज भएर नम्बर भएर चाहिँ 49 नम्बर प्लटको चाहिँ 52 को रेकर्ड अनुसार चाहिँ 49 नम्बर 49 प्लट हो र 7980 को रेकर्ड अनुसार 201 भयो भने चाहिँ त्यो प्लट चाहिँ मर्ज भएर चाहिँ 0 नम्बर हुँदा चाहिँ 201 मा आयो भनेपछि त्यसरी हामी वर्कआउट गरेर फिल्डमा गर्न मात्रै याद पाउने कुरो सर।
यो पूर्व पश्चिम उत्तर दक्षिण जुन चाहिँ 4 डाइरेक्सन छ नि
हजुर,
अहिले त अब इन्फर्मेसन टेक्नोलोजी आएर हामीले कुनै पनि मेसिन लाएर त्यो छुटाउन सक्छ
हजुर,
तर पहिले त्यो पूर्व पश्चिम उत्तर दक्षिण जुन चाहिँ ल्यान्ड डिमार्केसन तपाईँले गर्नुहुन्छ नि
हजुर,
त्यो चाहिँ के को आधारमा त्यो सही हो भनेर हामीले कसरी विश्वास गर्नु र के को आधारमा गर्नुहुन्थ्यो?
त्यो चाहिँ सर यस्तो हुन्छ, अब हाम्रो टेक्निकल रिपोर्टमा चाहिँ के हुन्छ, अब एउटा जब सर्वे गर्न जाँदाखेरि एउटा टेबल फिक्स हुन्छ, मतलब पोइन्ट फिक्स हुन्छ। त्यो फिक्स भएपछि नर्थ र साउथको नर्थ पोइन्ट र साउथ पोइन्टको कम्पास फिक्स गर्छौँ सर। फिक्स गरेपछि जब टेबल कहीँ पनि अब त्यो फिक्स भएको छ नि हिलिँदैछ भने त्यसले नर्थ डाइरेक्सन साउथ त्यो देखाउँदैन सर, हिलिबस्छ। त्यसले गर्दा त्यसलाई फिक्स गर्नलाई चाहिँ एकदम त्यो अब जुन चाहिँ टेबल हामीले फिक्स गर्छौँ त्यो टेबलको प्लेन त्यो चाहिँ एकदम लेभल मिलाएर एकदम फिक्स गरिसकेपछि जब नर्थ डाइरेक्सन र साउथको एकदम नर्थ पोइन्ट एकदम नअलिकन त्यो नर्थन साइड त्यो कम्पास देखाउँछ तब हामीले चाहिँ त्यसलाई चाहिँ फिक्स गरेपछि त्यो पोइन्टबाट चाहिँ सर्वेको एउटा स्ट्रेट लाइन हामी एउटा टार्गेट गरेर एउटा पोइन्ट गर्छौँ सर। त्यसको बादमा एउटा क्रस चेक उता हाल्छौँ। त्यसको बादमा चेक लाइन हान्छ। त्यो अनुसार हामीले राइट एङ्गल उठाएर त्यहाँदेखि सर्वे गर्न जाने हो। त्यो उहिलेको टेक्नोलोजी सर, पहिलाको प्लेन टेबल सर।
अहिले पनि त्यही छ?
अहिले पनि त्यही हो सर। अब अहिलेको चाहिँ के छ, इटिएस चाहिँ जिपिएस यो हाई टेक्नोलोजीको छ, त्यसले गर्दा उनीहरूले आफै त्यो सेटअप भइहाल्छ सर। अहिलेको चाहिँ अब मलाई त्यति आइडिया पनि छैन सर, अहिलेको भाइले गर्दैछ।
अच्छा,
त्यसले गर्दा चाहिँ म एकपल्ट गएँ सर, यहाँ तल यो आर्मीसँग गएँ सर, माथि भुसुकमा जाँदा आर्मीहरूको त्यही ल्याएको थियो जिपिएस सर्वे, उनीहरूको पनि त्यही रहेछ सर।
त्यो मिल्छ अहिले तपाईँको विचारमा पहिलेसँग?
अब त्यो सर अब ओपन उसमा त राइट एकदमै एक्ज्याक्ट आउँदछ। अलिकति फरेस्ट अलिक भएको ठाउँमा अलिकति त्यो सेटेलाइटले त्यो उयो नदिने ठाउँमा चाहिँ प्रब्लम हुन्छ सर।
त्यो तपाईँको छ अहिले पहिलेको फर्मुला?
पहिला हाम्रै यसमा चाहिँ अस्ति हामी गऱ्यौँ सर, लास्ट इयर।
अच्छा, त्यो जुन चाहिँ तपाईँको त्यो के भन्नुभयो, कुन मेसिन भन्नुभयो नि तपाईँले अहिले?
हजुर,
त्यो चाहिँ कसले बनाएको?
कुन सर?
त्यो मेसिन तपाईँको डाइरेक्सन देखाउने कम्पास
खोइ सर, अब त्यो सर्वे टाइममा पहिला अब कसले बनाएछ त्यो याद आइडिया भएन सर मलाई।
त्यो अहिले पनि छ?
रेकर्डमा कहीँ राखेको होला सर।
छैन?
सेटलमेन्टमा त हुनुपर्ने सर पहिला कि सर। अब अहिले त्यो चाहिँ अब सबै अब अफिस सिफ्टिङ हुँदै हुँदै जाँदाखेरि त्यो सबै डिस्पोज भयो सर।
पछि त्यो सेकेन्ड क्वेसन नि तपाईँलाई जस्तै दुईजनाले किनबेच गऱ्यो।
हजुर।
अब तपाईँहरूलाई एप्लिकेसन एउटा गर्नुहुन्छ किन्ने मान्छेले।
हजुर।
त्यहाँदेखि तपाईँको बियर काट्नु पऱ्यो।
हजुर।
त्यहाँदेखि डिसी अफिस, डिसी साहब या एसडिएम साहब एडिसनल डिसी कलेक्टरकोबाट पर्मिसन ल्यायो।
हजुर।
अनि तपाईँको स्पटमा गयो। गइसकेपछि चाहिँ तपाईँको के आधारमा चाहिँ यो एरिया रहेछ भन्छ? भरबडी भन्नुहुन्छ कि बा धन रसिद रिलाइ गर्नुहुन्छ, राजीनामा रिलाइ गर्नुहुन्छ कि के को आधारमा?
अब कहीँ पनि सर कसैले पनि अब जमिन किन्नु एप्लाई गर्छ नि सर। गरिसकेपछि त्यही हो सर, थ्रु अब कन्सर्न एरिया कन्सर्न अमिटमा आएको सर रिपोर्ट। त्यो आएपछि उहाँहरूले एउटा डेट फिक्स गरेर चाहिँ डेट दिन्छ उहाँहरूलाई। त्यो डेट दिएपछि चाहिँ उहाँहरूले भन्नु पऱ्यो त्यो दिन कन्सर्न पञ्चायतमा राख्नुहोस्। अनि सिमानादार बााउन्ड्री होल्डर तपाईँको जमिनमा जुन बेच्दै गरेको किनबेच भन्दै गरेको जमिनमा को उसको जमिन पर्छ उहाँहरूलाई पनि राख्नुहोस्। अनि किन्ने र बेच्ने त हुन्छै हुन्छ, त्यो कन्सर्न पञ्चायत पनि हुनुपर्छ, राख्नुहोस् र हामी आउँछौँ। त्यो डेट फिक्स भएको दिन जान्छ, रेकर्ड बोकेर सर। रेकर्ड बोकेर गएपछि उहाँहरूले अब त्यही हो सर, कुन प्लट कहाँबाट किन्यो इन्टायर त्यो प्लटको चाहिँ अब जस्तै 203 को प्लट सर्टेन एरिया बेच्दैछ या त डल्लै सलिड बेच्दैछ। सलिड बेच्यो भने चाहिँ सर अब सलिड बेचेको छ भने त सर अब त्यसको अब डाइमेन्सन त त्यो बााउन्ड्रीको जसको जमिन अब प्लटिङले भेट्छ त्यो आएको सर। इस्टमा वेस्टमा साउथमा त्यो इस्ट वेस्ट नर्थ साउथको त्यो त लेखिहाल्छ। अब एउटा सर्टेन एरिया पोर्सन बेच्दैछ भने सर कुन पोर्सन बेच्दैछ, वेस्टर्न नर्दर्न साइड बेच्दैछ कि वेस्टर्न साइड साउदर्न साइड बेच्दैछ कि इस्टर्न साइड। अब त्यो डिमार्केट गरेपछि डिमार्केट गर्नुभन्दा अगाडि तपाईँले बेचेको जमिन चाहिँ कहाँनिर किन्नु भएको छ कहाँनिर भनेर सोधिन्छ सर। सोद्धाखेरि अब त्यो प्लटहरू अब गएर नक्सा राखेर हेरेपछि अब इस्ट वेस्ट नर्थ साउथको अलिक त्यही हेरिन्छ। त्यो हेरेपछि त्यहाँदेखि अब बेच्नु भएको प्लट त अब जस्तै मनबहादुर सिमानाबाट चाहिँ यो बेचेको यति, अब धनबहादुरले बेच्दैछ, एउटा कसैलाई पनि हर्कबहादुरले बेचेको छ भनेदेखि त्यो पोइन्ट अब नाप्नु जाँदा चाहिँ अब यता सिमाना मनबहादुर सिमाना छ, त्यहाँ तपाईँको सिमाना यहीँ हो। लु त्यसो भए यहाँबाट कति बेचेको हुन्छ, त्यो अब उहाँले यहाँसम्म बेचेको हुन्छ, त्यहाँसम्म आएर देखाइदियो। जस्तै 20 मिटर आयो, 20 मिटर आयो भने 33 फिटमा उहाँ के भन्छ त्यो नक्सामा 33 फिटमा हामी पोइन्ट गर्छौँ। त्यहाँदेखि साउथपट्टि कति ल्याएको छ, अब त्यो उँधोपट्टि नि अब साउथपट्टि नि उहाँको सेलरकै अब बेच्ने मान्छेको जमिन रहन्छ भने त्यहाँबाट ठाडो नापेर कतिमा आउँछ, कतिमा बेचेको, कति प्लट अब कति एरिया बेचेको छ। जस्तो 70 फिट बेचेको छ भने 70 फिटमा 105 मा तल ल्याएर हामी डिमार्केट त्यहाँनिर देखाइदिन्छौँ। त्यहाँबाट यता मनबहादुर सिमानापट्टि आउँदाखेरि मनबहादुर सिमानाबाट आउँदा बसेको चाहिँ कम्ती हुन्छ। अब स्क्वायरमा हुँदैन सर, कोही ठाउँ चाहिँ 35 फिट भेट्छ। 35 फिट भेट्यो भने 35 फिटको हामीले 52 फिट आधा 52.5 फिट भनौँ न, त्यतिमा राखेर त्यहाँदेखि मनबहादुर सिमाना त्यही गर्नु। त्यहाँबाट मनबहादुर र उहाँले अब त्यो हर्कबहादुरले बेचेको सिमाना चाहिँ ठाडो नापेर तल ल्याएर चाहिँ त्यति देखाएपछि त्यो चाहिँ सेल गरेर ल्यान्ड भयो। त्यसको एरिया इस्ट वेस्ट नर्थ साउथ त्यहाँदेखि हामी त्यहाँ फिल्ड भेरिफिकेसनमा उहाँलाई दिन्छौँ। दिइसकेपछि त्यसको एरिया निकालिदिन्छौँ। एरिया कम लाएर एरिया निकालेपछि अब त्यो प्लटको जस्तै 40,000 जमिन 1 एकर छ भने उसले अब 25 डेसिमल किन्यो भने 75 डेसिमल त उसको रह्यो भनेदेखि यता उसको अब 25 डेसिमल उसले किनेको हुन्छ, त्यो चाहिँ डिमार्केट गरेर हामी छुट्याइदिन्छौँ। त्यो सर,
थ्याङ्क यू सर।
थ्याङ्क यू सर।
If you reference will be on the map, sir. जुन चाहिँ म्याप हुन्छ we refer the map first, and then we take into account the khasra also and the parcha with which the seller is having. The parcha is nothing but it's a photocopy. All the contents which are in the khasra is reflected in the parcha, sir. And as when time goes by, there will be transactions also. So first is the document which we refer is the map, the khasra and the parcha available, and then at the same time we go to the spot, and we sometimes there will be situations where the boundary holders have changed, or maybe their transaction has already taken place, but then like that has not been entered in the government records. Because of a physical money, we have to take these two aspects into consideration, sir.
No, what I am to see, that is the oral now, the verbal now transaction.
Yes.
As per the TP Act. Now, if there is a dispute saying that I have never disclosed regarding this particular identity of land to the seller, to the revenue supervisor, then how you defend?
So
Orally now, as per his now the deliberation, there is the oral now, as per the oral transaction.
yes, sir.
The concerned officer authority of the land revenue department or revenue department of any concerned district will measure the land. But if later on, if there is a dispute regarding this particular transaction, saying that orally they have done, there is no document, then how you defend? Saying that they have said so. On the basis of their assurance, we measure.
Okay. So we have to refer to the documents first, sir. That's the primary thing.
No. You will refer your document.
Yes, sir.
But the party document is not necessary. Say this money receipt, done receipt, Rajinama, those documents are not necessary.
So we primarily refer to the parcha only, sir. Money
Parcha.
receipt and all these things will be secondary when there are, in some unique cases only.
You rely your parja
Yes, sir.
on the oral submission of the party. Is it true?
No, the parcha which he will be having, no, sir, in
No,
possession.
he will hand over that parja, but how much amount he is going to sell? There is no document. He is orally submitting to you.
Mhm.
So on that particular circumstances, which transaction you will prefer? Orally or you insist on document?
Document, sir. We insist on document.
Document.
Yes.
I just wanted to, what is that called? तपाईँले सर्वे गर्नुहुँदाखेरि चाहिँ ओल्ड रेकर्ड चाहिँ हेर्नुहुन्छ भनेर भन्नुभयो नि अघि जुन चाहिँ फर इक्जाम्पल यो गुरुद्वाराहरू त्यो पोर्सनमा इज देयर एनी नोटिफिकेसन टु द्याट इफेक्ट? आई जस्ट वान्टेड टु आस्क द्याट केही छ त्यसको सर्कुलर अन नोटिफिकेसन?
I would like to add a little bit on what he has said
Manger.
before. तपाईँको 19 survey records from 1950 has been already, it was attested, all the records were attested. There were a couple of lands which were not surveyed then, that those are like Zonggu and Lachen and Lachung, and some lands which were directly under the control of the Shilal. Those were never surveyed also and attested also. But later on, when survey operation of 79 and 80 happened, there were some blocks which were surveyed but not attested. The reason being that during the first democratic rule of Qazi Saab, then the bazaar jurisdiction was expanded, it seems. And when it was expanded, there were transactions. Then transactions took place in favor of non-COI holders like businessmen and all. And again, during the Bhandari's reign, again the jurisdiction of bazaar was again restored back to the previous one. So there was a complication, in a sense, like those areas which were now, as per the 79 survey, those lands which were supposed to be shown as blocks in rural areas, there are already transactions. So there was complication, and the attestation, it seems the attestation officer had put up the matter before the government, and there was no clear specific directions, so that couldn't be attested. These are like some some of these examples are Gangtok block, Gangtok, some portion of Chanbari, Upper Tadang chain.
So in that event, it's necessary for us to see both this one.
No, ma'am. In this case, what we have to do is, since it was not attested, now for all practical purpose, 51 survey records will be used for this particular cases only.
Okay, that's what I'm saying.
Yes.
These
yes,
cases
yes.
will have to go back to 50-50.
50, yes, yes, ma'am.
Thank you.
I will be taking a session on old land records and survey settlement of 1979-80. As everybody knows that survey record of 1951 was the first cadastral survey done in Sikkim. Prior to that, we did have land records, in a sense like they were during 1920s, the authorities to maintain details and records of land was known as Akhjas, it seems, and those days this particular authority was actually framed to primarily collect khazanas from different places, and in this, as per this monastic, there was a monastic authority led by the head lamas who will be collecting khazanas, and then we have the landlords, Qazi, Tikadar and Mandals who would be collecting khazanas directly from the landowners. And on the later stages, we had during Akhjas, I believe there was no record keeping as such for the land records. So it was whatever you see, like as the word says, Akhjas is like whatever you see, like you through visual identification, you can. It was supposed to be like that was how lands were identified for different landowners. Then we, in the later stages in 1930s to early 50s, mandals and head lamas were again designated to collect khazanas, and at this stage I think there was some kind of written documents, like not like the cadastral survey just now, though they had some kind of written records where like some showing lands belonging to the monastic and showing lands in favor of general public, and these records were used to collect khazana. Now coming back to the survey settlement of 1951, the land records of 1951 was the first cadastral survey of Sikkim, and it was carried under the record writing and attestation rule of 1951. Physical survey started in 1952, and it took approximately 5 years to complete the entire state. Survey records of 1951 came into force in 1958. The land records of 1951 are in the measurement of acres, and the scale taken is 1:4,000. Now I shall be discussing on process followed for writing and attestation during survey operations of 1951. During the survey operation, landholders were called to the survey spot for boundary identification. Land records available with the concerned mandals, which means that Maza's records available with the mandals of the concerned blocks were referred. Plotting of land was done in the first place, then simultaneously map drawing and entry of plot records in the khasra was also done on the spot. The entries which are done in the khasras are, we have column number 1 which bears a serial number, column number 2 bearing plot number, column number 3 bearing height of the plot from sea level. This particular height of the plot from the sea level was measured to classify the land. Column number 4 bed column number 4 contained number of garas, slopes. Old days, like paddy fields used to be, just now also we have those paddy fields in steps, so number of slopes was written there. And column number 5 contained the Bastiwala's name, father's name, caste of the Bastiwala. Column 6, classification of the land as classification 1, 2 and 3 was there. Column number 4 contained total area. Column number 8 contained type of crops grown in it. Column number 9 contained area of cultivation land of the Bastiwala. Column number, so it was a precise one, because out of the total land which the Bastiwala had, it was all divided, it was classified into different purposes. Column number 10 showing fruits and other oranges growing on it. Column number 11 also showed specifically orange groves. And column number 12, banjo lands, uncultivated land. It was shown the quantum of banjo land that person had. Column number 13 showed the quantum of cardamom cultivation the landholder had in that particular plot number. Column number 4 showed khasmal land. If it was a khasmal land, then it will be reflected in column number 4. Khasmal lands like khasmal, gaucharan, cremation and burial grounds, other services, roads, park, bungalow, etc. Column number 15, which is in the right remarks column, that showed road reserves, market cremation grounds, and that even showed secondary holders who had been in possession of the land for more than 12 years. I think Aro has already exhibited a sample of khasra. Yes. Now I would like to take you to entries in Khatiyan. Khatiyan preparation done in alphabetical order of the landowners, name with the holding that landowners are in that particular revenue block. This will include both the ancestral and purchased land. After the survey, unattested copies of the parcha were issued to the landowners on the spot, and a notice period was given for attestation to be done. So within this period, if there was any discrepancy with the landowner or the measurement of the land, they could have the landowner could have appealed before the authority, for which the provision was there. And for those, if there was any objection, received from the landowners, then it would have referred to the appellate authority for redressal. So if there is any question on 1951 survey records.
Not on 1950 survey report, but again, सरले पनि भन्नुभएको थियो, आउट अफ क्युरियोसिटी
Yes, sir.
मलाई यो सोध्नु मन पर्यो कि सरले अघि भन्नुभयो कि प्लट हामीले गर्न सुरु गर्दाखेरि नर्थ वेस्ट डिरेक्सनबाट हामीले प्लट गर्छौँ भनेर नि वाट इज द रिजन अफ यो प्लट चाहिँ किन हामीले नर्थ वेस्टबाटै
Plotting of the north west.
यस्तो चाहिँ हामीले सर्वे गर्दा नि प्लटको तर्फबाटै किनभने तलबाट गर्दा चाहिँ स्लोप त्यो हुँदैन माथिबाट चाहिँ स्लोप काट्दै काट्दै त्यसको अल्टिट्युड अनुसार गर्न सक्छ त्यस कारणले गर्दाखेरि चाहिँ हामीले माथि प्लटिङ गर्दा नि नर्थ र वेस्टर्न साइडबाटै प्लटिङ सुरु हुन्छ त्यहीबाट 1 नम्बर जस्तै एउटा बााउन्ड्री झोडा बााउन्ड्री उतापट्टि एउटा हिन्दुम छ यतापट्टि राङ्का छ भने अब त्यो झोडा बााउन्ड्री भयो बााउन्ड्री लाइन चाहिँ अब एथेन्टिक बााउन्ड्री चाहिँ त्यो झोडा भन्छ झोडा त्यो चाहिँ 1 नम्बर पर्नु सरकार झोडा 2 नम्बरमा चाहिँ त्यो कसैको पानी मिलेर अब एकजना पासाङ भुटियाको आयो पासाङ भुटियाको के हो पानीको पानी अथवा अलैँच पनि आउँछ त्यसले गर्दा नर्दर्न साइड नर्थ र वेस्टर्न साइडबाट चाहिँ गर्दै गरेर चाहिँ लास्टमा एन्ड हामी यहाँ इस्ट र साउथ र वेस्ट हुन्छ जस्तै हामीले लेख्नेमाथि प्रपर लेख्छ लेख्दै हामी एन्ड तल हुन्छ त्यस्तै हिसाबले रेकर्ड टाइपिङ गर्दै तल गएर नर्थ र साउथको इस्ट र साउथको एन्डमा चाहिँ क्लोज हुन्छ त्यसरी नै त्यो रेकर्ड टाइपिङ हामी पाउँछौँ
हाम्रो हिली टेरेनले गर्दा अलिक भइसक्यो
अब प्लेन साइडमा हुनु त जता गर्दा हुन्छ अब हामीले यदि हिल साइड हुँदाखेरि त्यो स्लोप अब काट्दै काट्दै लानु पर्दाखेरि चाहिँ फिल्मलाई चाहिँ त्यसरी गर्छ एउटा सर्वेमा चाहिँ बेस्ट छ
थ्याङ्क यू सर र अर्को एउटा प्रश्न पनि सरले अघि भन्नुहुँदै थियो कि हामीले एकताल रिपोर्ट बनाइसकेपछि सेटलमेन्ट अफिसरले या रेभेन्यू अफिसरले त्यसलाई चाहिँ एटेस्टेड गर्यो भने चाहिँ त्यसको बादमा चाहिँ हाम्रो यो पुरा मानिन्छ भनेर भन्नुहुँदै थियो नि सर एटेस्टेसन अफिसर भनेर नि र एटेस्टेसन अफिसर चाहिँ हामीले कसलाई मान्नु सकिन्छ
पहिला त सर्वेको
सर्वे टाइममा सर अब टिम हुन्छ सर अब चाहिँ दिन्छ अब सर्वेले चाहिँ अब के भन्छ रिभ्यू इन्ट्री गर्दै जान्छ त्यो गर्दा सर्वे भइसकेपछि अब अल ओभर त्यो ब्लक सर्वे सकेपछि त्यहाँबाट चाहिँ उहाँहरूले चाहिँ इन्फर्म गर्छ कि डब्लुलाई कि हामीले चाहिँ रेभेन्यू ब्लक चाहिँ हामीले कभर गरिसक्यो भनेदेखि कहीँ अब उहाँहरूले गर्दै गरेको काम चाहिँ कहीँ बिचमा केही छ कि एथेन्टिक छ छैन भने चाहिँ उहाँहरूले क्रस चेक गर्न आउँछ इन्सपेक्टर एचएस आउँछ आएर हेर्दाखेरि उहाँहरूले गरेको कामहरू सबै कहीँ न कहीँ गएर चाहिँ अलिकति ओभरल्यापिङ के भएको छ भने त्यहाँ फेरि उहाँहरूले रिगर्नु आउँछ रिगर्नु आएपछि सर्वे गरेपछि त्यो ओके भएपछि त्यहाँदेखि उहाँहरूले चाहिँ एटेस्ट अफिसरलाई इन्फर्म गर्छ हामीले त्यो ब्लक चाहिँ उहाँहरूले चाहिँ कभर गरिसक्यो भनेपछि उहाँहरूले
एटेस्टेसन अफिसर चाहिँ मतलब को हुन्छ
एटेस्टेसन अफिसर चाहिँ फर सर्वे एन्ड सेटलमेन्टको लागि चाहिँ स्पेसिफिकली फर द्याट पिरियड अपोइन्ट गरेको हुन्छ एज पर 19 जहाँसम्म मलाई याद छ 79-80मा चाहिँ त्यति बेला कहाँको बाहिर पो थियो नि उहाँहरू एक्सपिरियन्सहरू उताबाट आएर उहाँलाई नै अपोइन्ट गरेको थियो दे फिनिस ए जब दे वेन्ट ब्याक सर यस सर
सर्वे रेकर्ड बनाउँदाखेरि त्यति बेला सर्वे गर्दा कतिवटा राजाकोमा भएको प्रपर्टी एन्ड मेनी अदर ल्यान्ड्सहरू छ कतिवटा चाहिँ सर्वे नै भएन र 50-52 को रेकर्डमै छैन भन्नु होइन सो अब त्यो छैन तर अब त्यो ल्यान्ड त छ नि त अझै पनि हराएको छैन अब भोलिको दिनमा या अहिले त्यो ल्यान्डमा डिस्प्युट भयो भने चाहिँ अब त्यसलाई हेर्नुको लागि चाहिँ कहाँ जानु थियो किन 50 प्रायः जस्तो मैले अहिलेसम्म जति पनि कोर्टमा केसेसहरू देखेको छु 284 को जुन चाहिँ भन्दैछ नोटिफिकेसन यो आयो यस्तो भन्दैछ तर सबैमा 50-52 नै हेर्छ रेफर गर्दा त ब्याक मैले जसमा बुझेको छु त्यो 50-52 नै हेर्छ र अब तपाईँले जुन चाहिँ भन्दैछ जसको चाहिँ रेकर्डमै छैन त्यो 50-52 को सर्वेमै छैन त्यो सेटलमेन्ट अब त्यसको लागि चाहिँ कहाँ हेर्नु जानु
म्याम इफ आइ एम नट रङ यसमा सर्वे इन अ सेन्स एन्टायर एरियालाई चाहिँ प्राइभेट स्टेट जस्तो भएको छ। यो एउटा सेमसुरेनको केसमा पनि भएको थियो। जस्तै त्यो जुन चाहिँ नामनामको द्याट एरिया त्यसलाई चाहिँ प्राइभेट स्टेट रिजर्भ फरेस्ट भन्दो रहेछ पहिला। इट वाज प्राइभेट स्टेट रिजर्भ फरेस्ट एन्ड इट नेभर ह्याड प्लट नम्बर्स अल्सो। एन्ड देन somehow the land revenue had executed a lease in favor of Semsuren as a temporary, is a interior measure only. And then new plottings were done to survey गरेर फेरि new plottings गरेर and plot numbers हरु assign गरेको छ. This is how we.
That was later.
This is later, ma'am.
So this is with regards to now Raja's private.
Yes, there are some places, not all, ma'am. There are some places which are.
I think there is Gangtok station map also.
Yes, ma'am. Yes, sir.
And so one more confusion I have. Private estate, for me, it would mean private estate of Chogyal, the land which is for privately for Chogyal. But then, while dealing with the cases and all, what I could understand, maybe I am wrong, please clear it, that there are private estate which is like exclusively for the Raja only, and there was private estate land which the Raja had kept it, Chogyal had kept it to give it to his subjects, बस्तीवालाहरु कतिजनाले दिनुको लागि पनि राखेको त्यो पनि प्राइभेट एस्टेटमै आउँदो रहेछ. सो के थियो प्राइभेट एस्टेट बेसिकली त्यसमा कन्फ्युजन मेन एक्सक्लुसिभली फर राजा नै हो कि प्राइभेट एस्टेट or one which he has kept it separately?
Ma'am, as far as I know about this private estate ko चाहिँ there are some land which are recorded in personal name of the Chogyal also, and besides that there is private estate. Private estate I believe is those land from where the Chogyal used to collect khazana directly. Primarily everything started from khazana collection only, but now in today's context now there are a lot of transactions happening. Before I'm sure there was no much transaction. It was primarily for khazana collection only, and those land which are recorded as private estate, it was directly under the control of the palace. So yes,
that means everything is of Chogyal only, we have to take it that way, or the land which is. See, there is confusion. I'm sure you will also agree to it.
Yes, ma'am.
Because it's one is exclusively for Chogyal and his family.
Yes.
Then there's another private estate also, which I understood is there Alakkai, which you are also saying khazana ko lagi.
Yes, ma'am.
So there is one big confusion.
जुन चाहिँ what ma'am is referring is that एउटा चाहिँ there is one land which is specifically used by the private estate, others was allotted to, was supposed to be allotted to the general public भनेको चाहिँ I have not come across that though. तर अब private estate को चाहिँ property को definition पनि is not very clear whether it's a government land or not, or then at the same time like the matter of private estate को जतिवटा properties it's supposed to be before the central government for final settlement never took place, it never happened. Maybe that at one point of time during I think early 80s and late 70s there were a lot of exercise done on this, but it never got materialized because what Chogyal wanted and what the central government wanted to give, and moreover I believe there are other implications to the Chogyal also. We himself stayed away from it seems. So this is it's a gray line, I think. Yes.
Thank you.
Yes.
Because of that, all of the cases.
There was a high-powered committee, and this, as I 90s and early 80s, they were working on it, but later on it never got materialized. Materialized by now. So it is just lying like that. Now I shall come to records of 1979-80. The preparation methods and mode which was used in 79-80s also similar to it was similar to 51 record. Only thing is the difference is that the measurement in as per the 79-80 is taken in hectares, and the ratio is 1:2000. And yes, I think this would be important point for discussion. After completion of the survey operations of 7980, notification was issued by the Land Revenue, which says that old records of 1951 is now seized from this effect. So my understanding, my personal understanding, though it is again depends on how you interpret. My understanding is that the notification saying that from that particular day, the records of 1952 is seized means from that particular day it will not be used. No corrections will be done on it. No corrections will be done on it.
It will stand as
Yes, it will stand as it is. This is what I feel. And from 7980 again, that will be carried forward to 7980 and all the corrections will be done on it. Wherever there is a complication with 7980 survey records, we have to refer back to that, our mother record, which is 51 record, sir. So that comes to end of my presentation. Since I'm not from the revenue cadre, I just try my best to give whatever I've understood during my stay in land revenues. If there's any question which I can answer.
So I have a question.
Yes.
I don't know whether any of you.
Yes, ma'am.
के भन्छ when अमिन जानुहुन्छ सर्वेको लागि है, there are three people like Sir said also. Amin हुनुहुन्छ, head surveyor and inspector. But according to my personal experience in wherever I have been for during the land survey, there are only one or two people, right? And it is not even sure that whether those three people are supposed to be there during the time of survey and whether they have to make a report where all of those people have to sign. And agi wale bhanule the boundary holders pani huनुपर्छ भनेर. So now which rule mandates the signature of which officers in a report, search report, and boundary holders को पनि वापस signature हुनुपर्छ कि पर्दैन or witnesses.
त्यो फिल्ड ट्रिप जाँदाखेरि चाहिँ अहिले सिक्किममै काम गर्नुपर्छ. पहिला त अब म्याडमको जमिन छ, म गएँ त्यहाँ गएर तपाईँले अब कहाँनिर सिमाना के थियो उहाँहरूले यहाँ भने त्यहीँ नापिदियो. भरे त्यहाँनिर केही डिस्प्युट भयो, म्याडम थिएन. म्याडमको जग्गामा हुँदाखेरि मेरो म पेन चाहिँ कसरी भयो भने एनओसी अब हामी बााउन्ड्री जाँदा मैले कहिले नापेको, कहिले त्यो फिल्ड गरेँ, म त याद छैन, म दिँदिनँ भन्छ होइन. त्यसले गर्दा चाहिँ अहिले प्रपरली फिल्ड गर्दा चाहिँ बााउन्ड्री होल्डरको उपस्थिति गरेर त्यहाँनिर उहाँले इनिसियल के भन्छ
त्यो चाहिँ तपाईँहरू
Any rule or law कि तपाईँहरूको यो practice procedure को हिसाबले चल्दैछ?
प्र्याक्टिसले नै पहिला गर्दाखेरि चाहिँ के भयो, अब एनओसी मैले देख्छु न भन्दाखेरि चाहिँ अबदेखि उता डाइरेक्सन तपाईँहरूले अब डिसिएलले भन्नुभयो. अब तपाईँ फिल्ड जाँदाखेरि चाहिँ बााउन्ड्री होल्डर राखेर मात्रै गर्नु.
त्यो नोटिफिकेसन केही छ लिगल?
त्यस्तो छैन.
एज पर ल चाहिँ अब तपाईँहरूको त्यस्तो केही म्यान्डेटरी भनेर केही छैन त्यस्तो.
For the survey को लागि चाहिँ 50-52 मा चाहिँ this provision was there for survey operation. So I believe from त्यही पर follow up गरेर त्यो format मै maintain गरेको छ होला म्याम. So basically like unlike other states we don't have a land revenue manual or a land revenue act. All we have is what we refer is the यो तपाईको survey operation को जुन चाहिँ land record writing they follow गर्छौं. So तपाईहरुले पनि you can always check the internet, basically त्यही पर follow हुन्छ. However, we are on the process of now coming up with the land revenue manual so that it becomes easy for everybody to refer. We have just started, sir.
And I think if you start with that, cases will become multi-visa. This is like this.
And I do not know whether this question will be asked for any of you, but then I have one question. I mean, I was thinking about this. Since so many cases, obviously Sikkim is a protected place, so it is not everybody can buy everybody's land, right? Just like
Yes,
land,
yes.
generally kinu sakdan hai. So, but then so in most cases, what happens is people have taken loans, right, and they
Yes,
are
ma'am.
unable to pay back the loan. So the banks take it, auction garcha, auction garera becha. But then auction garदाखेरि they don't see who's the buyer, no. So in such cases, when people are like Bhutia lands are, left lands are,
Yes, ma'am.
or a general person like किन्दैछ अरे किनिसक्यो अरे है, otherwise a person who doesn't have a COI उनीहरूले किनिसक्यो त्यसको बादमा रेजिस्ट्रेसनमा के हुँदैछ? I want to know that. If it has come to you.
Yes, it has come to us. It has come to us. जस्तै कि आजकल हालैमा चाहिँ अब त्यो यो जुन चाहिँ अक्सनमा नन सीओआईले एक दुईजनाले किनेको जो हुँदो रहेछ, बट वी डोन्ट रेजिस्टर इट एट ऑल किनभने द प्राइमेरी रिक्वायरमेन्ट इज सीओआई, ओके म्याम. And when there is when such auction is taking place in Nagar Panchayat area, and if the highest bidder is a residential certificate holder, then this can be considered with the approval of the government. This is one choice. Otherwise, rampantly, nobody can. Kosale bid jite bha pani, it is his problem, and we will not register it.
Go back to Portugal. Thank you.
Sir, you were talking about the notification which the government had issued
Yes.
seizing 1958
Yes.
survey. So,
51 survey records.
yes, 50,
Yes, sir.
58 survey. So if you have that reference number, can you share it with us? Your
Yes, sure, sir.
notification number.
Sure, sir.
हामी ले पनि यसो निकाल्ने
Sure, sir.
Sure.
Sure. So we have here. I'll provide you a copy. Thank you, sir. Thank you.
It's a personal experience here where it seems one of the lost the cadastral to the Purano map which we refer to while surveying in area. Which with regard to one particular area. So let's say that is with regard to 51, 52, right?
Yes.
After that you have maybe if that area has 79, 80 report, you can look at that also. But then if there is an anomaly in that 79, 80 records, then what do you do? What do you look at? Because 50, 51 ko ta haraisakyo, 79, 80 ma pani anomaly cha. Because the parties are saying that it is just like a problem, they are not referring to it. So in such a case, where do we look at?
At the most, we can just do a spot verification, okay, and rely on the boundary holders, and whatever land is left, then this seems to be the only practical option.
So 50-51 ko map you have that drawings
Yes.
first
Yes,
scale
ma'am.
of your thing, na? The 79-80 map map ne baneko cha ki it's only just the records.
79, 80 मा म्यापै छैन म्याम. Only thing is, as I mentioned before, त्यो तपाईको ratio चाहिँ यहाँ चाहिँ it's in hectares. So the ratio of the scale will be 1:2000. Before it was 1:4000. हजुर. What we do is, if there is a map, there is a 52 core map, we trace that, and then with the tracing paper, we overlap with the new thing, and I try to identify. Sometimes it is usually all the cases are not exact what is there. The boundaries will change, the maps will change, but then when you take the tracing map over the 79-80 record, then from there you can make out, कुन चाहिँ extra जमीन कहाँ के भएको छ भनेर.
And when a particular portion of land is sold from one plot, just let's say 540 per acre, it goes as 540p or 540/ something.
Yes.
So त्यो particular land चाहिँ तपाईको 540 कै land, if that particular portion has not been sold from that portion, अर्कै जमिन छ अरे त्यो पनि 540/ यस्तो भनेर हुन सक्छ नम्बर कि it is हुँदैन नि हैन.
त्यस्तो त हुन सक्दैन, because every plot will have its unique number. त्यो पनि हो, त्यो repetition त हुन सक्दैन.
सर 1970s को सर्वे रिपोर्ट छ र जमिन त अब यस्तो हो सरले तपाईले भन्नुभएको जस्तो बाउन्ड्री होल्डर्सहरु चेन्ज हुन्छ र तपाईहरुको एक्सपिरियन्समा र अनुभवमा टोपोग्राफी जुन चाहिँ जमिनको टोपोग्राफी छ त्यो चेन्ज भएको तपाईहरुले कतिवटा केसेसहरु पाउनु भएको छ भने नि. कारण जहाँ चाहिँ प्राय ल्यान्डस्लाइडहरु हुन्छ, प्राय कतिवटा के हुन्छ भन्दा खोलाहरु हुन्छ है सर, खोला नालाहरु हुन्छ. अब खोलाको हिजो अस्ति पनि त्यहाँ जोरथाङको माझी टारमा पनि होइन माझी गाउँमा पनि जुन चाहिँ खोलाको त्यो कर्भ छ त्यो चेन्ज हुन्छ नि त कोही बेला जमिन कोही बेला यता धसिन्छ कोही बेला ल्यान्डस्लाइड आइन्छ अब रेगुलर कोर्स खोलाको गइरहेको यता आइन्छ यता आउँदाखेरि यहाँको जति जमिन हुन्छ त्यो जमिनलाई पानीले लाँदै लाँदै गरेर त्यो जमिनहरू पनि बिलेर जान्छ है त्यस्तो केसेसहरू पनि तपाईँहरूको अनुभवहरूमा 50s र 70s मा या 50s र त्यसको बादमा कतिवटा चेन्जेसहरू छ देख्नु भएको छ
सिङ्गापुर यता पेट्रोल पम्प छ पेट्रोल पम्प मुनिपट्टि केसेस छ खोला डाइभर्ट भएर आएर 7980 मा चाहिँ चिसो पानी ब्लकको चाहिँ लिङ्चे ब्लकको चाहिँ चिसो पानीमा यता वालीपट्टि डाइभर्ट भएर अहिले पोजिसन देखाउँछ त्यही एउटा अब हाम्रो मदर्सहरूको पनि छ केस अब
त्यो केसमा चाहिँ के गर्नुहुँदैछ तपाईँले त्यस्तो केसेसहरू
त्यो चाहिँ म्याडम पहिल्यै अब 2018 मै होला सर्वे गरेर चाहिँ म्याडमले दिएको छ रिपोर्ट त्यो चाहिँ अब अहिले अब कोर्टमै छ अब कहिले हेरिङ छ मलाई त्यहाँ छ उहिले अब 50-52 रेकर्ड हुन्छ पर्छ उहाँहरूलाई मागेर दिएको छ सिङ्गिरता छेत्री हजुर मार्तल के छेत्री छ दुईजना दिएको छ डम्बरसी छेत्री दुईजना दिएको छ अब उहाँहरूले फिल गरेर चाहिँ रम्फूको स्टाफबाट चाहिँ रिपोर्ट आएको छ आउँदाखेरि चाहिँ सर्टेन एरिया चाहिँ अहिलेको न्यू करस्पोन्डेन्ट प्लट चाहिँ यो चाहिँ अब चिसो पानी भएको परीक्षण दिएको छ त्यो चाहिँ उहाँले चाहिँ रेगुलाइज गर्न तर चिसो पानी त्यहाँ सिङ्गताम पानीपट्टि उता लिप्चे ब्लकको जमिन चाहिँ चिसो पानी पर्दैछ खोला ड्यामभित्र गयो उता जमिन बाली आएछ अब यो कुरा छ हामी के गर्छ कोर्टको च्यालेन्ज छ
Sir, I have one question.
फिल्डमा जमिन छ फिल्ड नक्सामा जमिन देखाउँछ फिल्डमा जाँदा जमिनै छैन सक्यो यस्तो छ अहिले यो पाचकमा एउटा आएको छ बन्डा गर्दै गयो उहाँहरूले जमिन बन्डा गरेर 3 जना दाजुभाइको बन्डा भयो बन्डा गर्दा जमिन सक्यो अब हामीले भन्छ तपाईँको जमिन सक्यो भने उहाँको जमिन उता देखाउँछ हाम्रो जमिन यति हो भन्छ अझै उता छ त्यसले गर्दा चाहिँ अब भिजिबल के छ त अब उहाँ 52 मै जान्छ 52 को रेकर्ड अनुसार हाम्रो बाजेको चाहिँ अमरबहादुर कसको नाममा छ भनेर बाजेको नाम दिएर आएको छ उहाँले अब त्यो अनुसार गर्दाखेरि त्यो एक्जिस्टिङ जग्गाको जमिन चाहिँ फेरि हामीलाई रेगुलाइज गर्यो भन्छ यो प्रब्लम छ सर
अलरेडी अर्काको नाममा हुन्छ
हजुर त्यो त अब अलरेडी अर्काकोमा छ नि अर्काको छैन त्यो एरिया चाहिँ भ्याकेन्ट नै छ अपोजिसन उहाँको छ तर डिमान्ड गरेर जाँदा त्यो चाहिँ जमिन चाहिँ उहाँको पार्टिसन गरेर जाँदा एन्ड हुँदैछ यस्तो भएको
So, do we need to pay a certain percentage of the land, total land value to consideration for registration, sir?
Yes.
So,
Yes.
what percent, sir?
For the purpose of registration, 1% as a stamp duty and 4% for registration fee.
Both
Depending on the consideration value.
Yes.
Now, what happens is in practical cases, a lot of people conceal the consideration value.
Yes.
You know, they shrink it down. So for this, we have come up with a notification of block rates. So block rates, we have given block rates as per I think acquisition rate. You know, we've taken that land acquisition rates, and we have given block rates. So whenever there is a transaction, this 5% will be charged on the consideration value or the block rate, whichever is higher. So at the end, 5% will be charged.
So that total consideration of the land will be assessed on the basis of that notification, sir? The value of land?
Consideration value will be like the seller, what the seller is selling for, you know.
Yes.
Yes.
So it applies to both sale and gift.
Gift ma चाहिँ छैन. Gift ma पनि अब what happens is, if there is a blood relation, then gift is allowed, and we charge only 500 rupees per registration.
Yes.
But otherwise, then again we have to take the block rates. Being that sometimes people, they just pretend that it is actually a transaction of a sale, but then to save on the registration, they will say this is a gift, you know. So that is not allowed.
Thank you, sir.
Land Revenue and Register Management Department. So I would like to extend a very welcome to all who are present in this session. So in this session, I'll be covering topics like what is land surveying and measurements, then Khasa, Khatiyans and records. So I hope this be able to give you some basic ideas. So now this session will be some technical session and it will involve some kind of mathematics also. So now starting with surveying. So what is surveying? So the surveying is the technique of determining the measurements of points on the surface of the earth by means of direct or indirect measurements. So this direct and indirect measurement means measuring the horizontal distance and measuring of vertical distance like elevations, height, and the angular measurements like inclined measurements and everything. So basically this surveying is art of establishing points by by linear and angular measurements. As we know that there are different types of surveyings like hydrographic surveying, cadastral surveying, and astronomical surveying. But in Land Revenue Department, we deal with cadastral survey. So this cadastral survey, it is relating to fixing of property lines, fixing of boundaries, calculation of area of the land, and the transfer of properties from one owner to another. So the purpose of survey. The purpose of survey is to prepare a cadastral map. So this cadastral map, it shows the boundaries of fields, plots, houses and other properties and other physical features on the map. This is the map. Over here you can see the plot numbers. These are the plot numbers. Plot numbers, the boundaries, everything it's there on the map. Next map. This is also the cadastral map. Over here you can see the physical features, the roads, the fields where the plot numbers have been mentioned. So now the instrument used in the survey operation of Sikkim 1952 and 790. The survey operation in the Sikkim was done by this plane table survey. So the first survey operation in Sikkim was conducted in the year 1952 and the surveying method used was plane table. The unit of measurement used was acre and decimal, and the scale adopted was 1:4000 and 1:1000. That means 1:1000, this scale is used in Gangtok areas, and for other area it is used 1:4000. And the second survey operation was conducted in the year 1979-80, and the unit of measurement used in the second survey operation was hectare, and the scale used was 1:2000. And this capacity survey 52 plane table meter, 7982 plane table meter. And the survey operation of 1950-52 was effective till 1984, and by this notification dated 1984, the old land record of 1951, which was existing in the state of Sikkim, it was ceased to be in operation. And now till date we are using the survey records of 1780, sorry. So this is the notification where the 1952 record is still in use under Gangtok district. So this is the Gangtok station, Pioneer Reserve, Devrali. So on this revenue blocks, this revenue blocks, this 1952 record is still in use because the 1980 records were not attested in these areas, in these revenue blocks. This is Gangtok station, Pioneer Reserve.
I just wanted the number and the date.
Okay, so the notification number is 26 November 2020.
So if you can share a copy of
Yeah, sure, sir. Sure. Sure.
Dated?
This is notification dated 26 November 2020. This is the method of, this is the plane table survey. The surveyor is doing the plane table. This is just a picture of plane table survey. So this plane table surveying, it's a type of surveying in which the observations, this is some kind of technical. So I just want to give some brief idea how is plane table surveying done in the field. So it's a type of survey in which the observation in the field and the plotting are done simultaneously. So this, so the map which is drawn by the surveyor in the field, the map or the plan which is drawn by surveyor in the field, while the area to be surveyed is before his eyes. So this main object of this plane table survey is to measure the horizontal distance, or the horizontal point of the distance. Horizontal point is measured. So this is the picture where the plane table surveying is done. This is point P and Q. Here the observation in the field is done and the plotting is done in the sheet of the paper. Field observation. Surveying in the field using plane table method.
How does this actually work? कहाँ राख्नुहुन्छ तपाईँ चाहिँ त्यो just
त्यो चाहिँ यो चाहिँ तपाईको फिल्डमा हामी फिल्डमा राख्छौँ.
And that is what. Is there any particular direction?
So actually यो चाहिँ तपाईको it should be aligned, it should be like on the direction of the magnetic north. तपाईको magnetic north मा राख्छ यो चाहिँ. So from here we will take the observation. Suppose अब एउटा point छ अरे, so we will take the observation with the help of your LED भन्ने हुन्छ. So your 1979 and 52 survey was done with the help of plane table survey. The जति पनि cadastral survey छ, it was done with the help of plane table survey. So this is the plane table. This is ranging rod. This is the ranging rod. You will take the distance. Just a surface sketch. So these are the equipments and accessories for plane table. So this is the your whole setup. This is the plane table. This one is LED, compass. Then this is the tripod, center, plumb bob. So now this is the LED. Now this is used for the sighting of an object. Suppose there are points are there. So for the sighting of the point, you use this LED. And now scale is attached on this edge for measuring the length in the sheet of the paper. LED. And the sighting of an object with the help of LED. This is how a surveying or the measurement is done in the field. Just this is point P and Q. Yeah, suppose this is the object. So this is the point P. With the help of this LED, you are measuring the distance, and this distance you are plotting on the sheet of the paper using some scale. This is plumb bob. Table suppose this is the fixed point. So you point transfer the plumb bob is used. So now this is the point. Now you want to transfer this point on the sheet of the paper. So this is the surveying instrument which transfer the point on the ground to the sheet of the paper. This is tripod, and this is used to support the plane table. Spirit level. This is what is this? This is an instrument designed whether the surface horizon. Just though you survey the plane table is to incline. So with the help of this bubble tube, this plane table will be horizontal along with the plane surface. But the LS horizontal actually. So it is used to make a line of sight horizontal. But this bubble center your table will be horizontal. So this is leveling a plane table with the help of spirit level. Basically level it's just a picture. So this is the magnetic compass. So this is the main thing, like compass, it is used to point the plane table towards magnetic north. So whatever measurements we do in the field, it is done with the reference of north direction. So it's one of the most important thing whenever you do a survey. So plane table oriented in the direction of north with the help of compass. So field ma ke huncha bhanda feri tapaiko यो compass, when you keep the compass on the plane table, त्यो टेबललाई घुमाएर तपाईँले ओरिएन्टेट गरेर चाहिँ हैन सेट गरेर चाहिँ त्यो नर्थ डाइरेक्सनमा अलाइन गर्छ, and you will draw a north direction in the sheet of the paper. So with the reference of this north direction, all the measurements are being done. So this is the revenue chain or surveyor chain. This is it is a 66 feet long chain, and this is used in cadastral surveying. It is divided in 16 links, and the length of each link is given over here. This 2.06, 2.5 feet. So this chain was used in the survey operation in the state of Sikkim in 1950-51 to Surveyma and in 1970 to Surveyma. So this is the picture of chain. The ranging rod, it's used to sight an object. मतलब जति तपाईको स्टेशनमा यो if the point measure गर्नु छ भने you'll keep the ranging rod over there and you will measure the distance. So this is elidate. Again, I've already explained, elidate is a straight ruler kind of object. It's used for sighting of an object. Plumber, it's used for transferring the point on the ground on the sheet of paper. Spirit level, used to level the plane table, tripod. Compass, it's used to mark the north pole on the drawing sheet. Chain, for measuring the horizontal distance, and ranging rod used for marking the position of points. So now the purpose of plane table survey, it's to prepare a plan or a map. And this map, it's a two-dimensional representation of the area. In cadastral survey, we don't take the elevation. So only we take two-dimensional, that is elevation. We are not concerned with elevation, height. Cadastral map. So cadastral map, it is the form of land records. It shows boundaries of different parts of land pieces based on the length, area and direction and other physical features. It is used to know the ownership status. It helps in the transaction of land, and this cadastral map, it is maintained by Land Revenue Department. So now scale. So what happens in the field is like the area which is being surveyed is very big. So the purpose of so what it's being done is like the scale. The map, the area is converted to some scale on the sheet of paper. So the definition of scale is it's the ratio of distance marked on the map to the corresponding distance on the ground. That means suppose like suppose 1:5,000 bhanere. So the 1 unit on the sheet of the paper represents 5,000 units on the ground. Suppose the length between 2 points on the ground is, suppose if you say, if it's 5,000 meter bhanere, suppose. So that it is represented on the sheet of paper by using this scale. So the scale which was used in 1952 survey, it was used as 1:4,000. That means the 4,000 units on the ground will be represented by 1 unit of the length on the sheet of the paper. Similar, this 1782 survey, this is 1:2,000. That means 2,000 units on the ground will represent 1 unit on the sheet of the paper. Scale. So these are all these methods of measuring device which is used in surveying. So this is measurement with the help of pacing. So this kind of measurement is only used for rough estimation. It's just to know the distance between A and B. And it's a very simple technique. So it's mostly employed in preliminary surveys. So pacing. What is pacing? Pacing is just pacing means the distance between 2 points is determined by number of steps taken. It's just suppose from point A to B, if the number of steps taken is 15, and suppose the average length of the steps taken by the surveyor is 2 feet. So that means 15 into 2, that the approximate length between A and B will be 30 feet. So it's just a rough kind of survey. So this is point A and B. The surveyor is measuring A and B with the help of piecing. The measurement with the help of pesometer. So this pesometer, it's an instrument shaped like a watch, and it is carried in pocket or attached to one length. So it records the number of paces, and it avoids the monotony and strain of counting the paces. So compared to the one measuring with the help of this, with the help of this pacing, and this is pesometer. The function of both is same, but pesometer. So measurement with the help of pedometer. So this pedometer is a device used to measure the distance automatically. So it is similar to pesometer, but difference is that pesometer counts the number of paces, whereas pedometer records the distance. This is measurement with the help of odometer. This odometer is an instrument that measures the number of revolutions of the wheel. So the number of revolutions taken to cover the length multiplied by the circumference of the wheel. So distance is number of revolution into circumference of wheel. This is the measurement with the help of chain or tape. So this is the most accurate and precise measurement, and the distance between the 2 points is measured with the help of chain or tape. And these are the measurements with the help of modern and advanced device. This is theodolite, and this is designed to measure vertical and horizontal angles, horizontal distance and height, and the coordinates of a location. And it works with the help of software installed in this device. This is GPS. So it is a satellite-based navigation system. It is used to determine distance, used for navigation, monitoring object or personal movement, and creating maps. So these are the procedures which is done in surveying. This is called reconnaissance. Number 1, marking of fixing of survey stations and running survey lines. So the first reconnaissance survey. So this is just a preliminary inspection. This is just a preliminary survey. So the preliminary inspection of area to be surveyed is called reconnaissance. So the surveyor inspects the area to be surveyed in order to fix the best position of survey line and survey station. The rough sketch of the area to be surveyed is prepared, and general arrangement of lines and principal features such as building, roads, etc. is shown. So this is just a preliminary kind of survey before the actual survey is done. So this is marking and fixing of survey stations. This is the main station A and B. This is the main survey line, and this is called tie line. With the help of this tie line or tie station, you can take the adjacent details. But you will take the distance of the nearby locations along the main survey line. Survey station. So the survey station is the point on the chain line, and it can be beginning or at the end. So this is the main survey station A and B. Main station, it commands the boundary of the survey. So this main station are placed along the boundary line, boundary of the area. And these tie stations are the points selected on main line. And this object of tie station is to take the details of nearby objects. So, running survey lines. So after the completion of this preliminary work, chaining is done. Means the measurement is done from one point to another, and the details, adjacent whatever details are being noted throughout the survey line. So So suppose this is the plot, sir. Suppose this is the plot, this is the boundary. So these are the main stations A, B, C, D. So these are A, B, C, D. These are the main station, and it's also called control point. So control point, and this is the baseline. The biggest of the main survey line is called baseline. So from here, all the measurements are done. So suppose this is the area, and all the measurements are done along through this line. On all the details are being taken with the help of this baseline. So this is how it is done. Suppose this is station A. This is the station, and from here, the chaining is being done, and all the adjacent details, it is being located with the help of this survey. So this is the field book. So this is the book in which this tape or chain measurements are entered in the field. So a line, it is being drawn from the middle of the sheet, in the middle of each page, which represents a chain line. Over here, this is a single line booking, double line booking. It's used in the field, basically. And whatever thing the measurement is being done, suppose whatever the chain it's being taken, it's recorded here. Field book. This is the cadastral map as per the digital records. So this is land measurement units. The standard measuring units to measure the length of land is feet, meters, centimeter, and inches. So its conversions are 1 feet is 12 inches, 1 meter is 3.28 feet, so 1 meter is 100 centimeter, 1 inch 2.54 centimeters, 1 kilometer 1000 meter, 1 meter is 100 centimeter, 1 chain is 66 feet, 1 inch is 2.54 centimeter, and 1 kilometer is 1000 meter. So these are some conversion units for this measuring of lengths. The standard for area of land, the standard units for calculation of area is square feet, square meter, hectares, and acre. So 1 acre is 43560 square feet. Similarly, 1 hectare is 107640 square feet. 1 acre is 10 square chains. 1 hectare 224.71 square chains. 1 hectare is 2.47 acre, and 1 hectare is 10,000 square meters. So now few examples. I have this is some few examples about conversion. This is kind of mathematics. Suppose a plot of land is measured in the field, the dimensions of which are 50 feet and 60 feet. So now this has to be calculated in hectare. The area has to be calculated in hectare. So the area plot will be, suppose if the area plot is length is 50 and breadth is 60, so area equal to 50 into 60 is 3000 square feet. Now converting this 3000 square feet into hectare, we divide 3000 by 107640 square feet, since 1 hectare is 107640 square feet. So the area will come to 0.027 hectares. Suppose the plot of land has a dimension of 100 feet by 200 feet. So calculate the area in acre. Area equal to 100 into 200 feet is 2000 square feet. And now 1 acre is 43560 square feet. Now converting this 2000 square feet into acre will, we have to divide 2000 by 43560 square feet, since 1 acre is 43560 square feet. 589640 units of land is measured in square feet by surveyor, and it needs to be converted into acres for record keeping purpose. So the area will be, area is 589640 square feet. So since 43,560 square feet equals to 1 acre, that means therefore 589640 square feet is, we have to divide 589640 by 43560 acres, since 1 acre is 40,560 square feet. So these are just some examples in order to know how the area conversion is done in the field. So a plot of land surveyed by a surveyor measures 15 hectares. So now this 15 hectares, it needs to be converted into acres. So what we do is, since 1 hectare is 2.47 hectares, so the 45 hectares converting into acre, we multiply 45 hectares by 2.47 acres. So it will come to 37.05 acres. So this is a similar type of conversion. It is in square meters to hectare. Since 1 hectare is 10,000 square meter, so the area will be 52,200 divided by 10,000 square meters. So now this is some example of scale conversion, how the scale is converted from the field on the sheet. Suppose if 15 kilometers is represented as 1 centimeter on the map, that means 1 centimeter on the map is 15 kilometers on the ground. So what will be the actual distance between two cities if they are 4 centimeters apart on the map? So since distance between two cities on the map is 4 centimeters and the scale given is 15 centimeters equals to 15 kilometers. Sorry, 15 kilometers. Therefore, if 1 centimeter is 15 kilometers, then 4 centimeters will be 4 into 15, that is 16 kilometers. The scale of a map is 1:50000. So what is the actual distance between 2 towns if they are 4 centimeters apart on the map? So distance represented by 1 centimeter map is 50 kilometers. Therefore, the distance represented by 4 centimeter map will be 50 into 4, that is 200 kilometers. Converting 3 hectares in meter square. Since 1 hectare is 10,000 meters square, therefore 3 hectares will be 3 into 10,000, that is 30,000 meters square. So after the completion of survey, the record prepared is Khasra, Khatiyan, cadastral map. So this, after completion of survey, the numbering of map is done. So numbering is done from the northwest corner and ends at southeast corner. So it starts from northwest and the numbering of the plots, and it ends at southeast corner of the map. And if any plot or plots are left out while numbering due to oversight, it shall be numbered in the same serial after the last number of the block as denominator and the number of any adjoining plot as numerator. This is done in during report writing. So the survey, when it is completed, so these steps are being followed. So this is as per that survey and settlement rules general 1988 code. So an index preferably in the northeast corner or in the available blank space of the map shall be prepared showing the following particulars. So it's like this: name of a block, name of ilaka, name of district and subdivision, year of survey, unit of scale. All survey sheets shall be numbered serially, and in the margin of each sheet, reference of adjacent sheets shall be made in bold letter. The north pointer and the scale of the map shall be shown in each north point or north direction. So it is shown in the map like this. This is the north direction. Name of the surveyor who has surveyed the block to be shown in the bottom of the map. So this is the name of the surveyor. It's written over here. Surveyor ko naam bhanera lekheko huncha. And now this is khasra. So this is the important part of land record. So the khasra plot number is a number which is provided to an owner of land for a particular plot. So this is all your topic plot numbers here. So the plot numbers. So it's just like an Aadhaar card, which serves as an identity proof. It gives information about the particular plot of land. So khasra book contains details of plot numbers in chronological order. So it starts from 1, 2, 3 like this. And it consists of a plot-wise description of ownership area, classification, share of ownership and the status. So it identifies which piece of land is owned by whom. And this is the prescribed form for khasra. Your form, it's there. So khasra heading ma column 1 will be plot number. Column number 2, name of the field, approximate height means the elevation of the plot of the land. From the mean sea level, so number of terraces, this is the number of terraces, name, parentage and address of landowner, kind of land, total area of plot, crop, and the area which is under cultivation, area of double crop, column number 11 will be area of orchard, area of banjo, column number 13, area of cardamom, area of khasmal. So in Nepali it's written like Bari Kunam, then Andaji ko yo pahnuस् न सबै यही Andaji uchai means elevation. यो चाहिँ हजुर यो approximate height भन्यो. बारीको नम्बर बस्तीवालाको नाम उसको बाबुको नाम एड्रेस माटोको दर्जा हजुर हजुर टोटल एरिया अफ प्लट पानी खेत होइन त्यो त खस्सा हो नि काइन्ड अफ ल्यान्ड भन्छ नि काइन्ड अफ ल्यान्ड प्लट नम्बर हजुर खस्सा सो प्लट नम्बर इज एन्टर्ड इन So Khatiyan, it means the record of rights, and it contains detail of land holdings, a name of the individual landowner, his total land, plot numbers, corresponding area. So annual land rent of the individual holdings, it's recorded in Khatiyan. So this is the prescribed form for this Khatiyan. So this entries in Khatiyan is made on the basis of khasra. So serial number of Khatiyan or holding number is recorded in column number 1. So it's my holding number also, total holding number. Then the other one is name, parentage, name of landowner, score address, parentage. It's arranged in column number 2. And the name of the locality of the plot. Suppose the name of the plot, plot number, it's mentioned in the khasra. Suppose plot number. नाम हुन्छ नि प्लटको के प्लटको नाम बारीको नाम पनि हुन्छ नि बारीको नाम सो इट्स लाइक नेम अफ द प्लट नम्बर्स द नम्बर्स इज असाइन त्यहाँदेखि एरिया अफ इरिगेटेड प्लट्स क्लास 1 क्लास 2 क्लास 3 इट इज रिकर्डेड अन द कलम नम्बर 5 6 and 7 ड्राई फिल्ड 8 कलम नम्बर 8 9 10 मा चाहिँ ड्राई फिल्ड एरिया एन्ड ड्राई फिल्ड इज रिकर्डेड Manger area under column 11. Total area of land shall be recorded in column number 12. Total area of land under orange, apple is recorded in column number 13. Area of land under area of land, cardamom field shall be recorded in column number 14, and This area of government land is recorded in column number 15. The land drain is recorded in column number 16, and this is the remarks column. So now Parcha. So Parcha is it's a copy of Khatiyan. It's a copy of Khatiyan. It's a record of right.
So Khatiyan and Parcha.
Khatiyan is maintained in the office, and the copy of this Khatiyan is given to the.
Khasra is maintained in your office.
No, Khasra, Khatiyan is maintained in our office. Khatiyan is the replica of Parcha. Whatever format it's there in the Khatiyan, same it is in Parcha. But Parcha is issued to the individual landowners. So it is a record of right. It contains information about ownership of land, and it shows the name of the landowner, name of the plot number and area and type of land. So this is the Parcha. It's based on 1952-52 records. Sicheko, the record which is still in use on the Gangtok area. Siche, the records of 1952 is still in use. So this is just one example how the Parcha is issued based on 52 records. Record issue this. And this is the Parcha based on 1979. And the Parcha which is used on 1952, so this has not been computerized. 52 ma record issue compressed. And this is based on this ILRMS software. Record issue. This is 780 records.
What has been mentioned.
So Khatiyan number is a total holding number. Suppose the Khatiyan number total number of plots will be mentioned in the Khatiyan. And the Khasra is like it gives you the Khasra is just a book. It gives you the information of the plot numbers. What is the plot number? There is a difference between Khasra and Khatiyan.
What is Kaifiyat?
What's it?
Kaifiyat.
Kaifiyat, it's a remarks column. Kaifiyat, this is Kaifiyat, your remarks column.
Sikkim, Chairperson Judge in charge Sikkim Judicial Officers. His Lordship, after finishing today matter fixed on the board, all the way come from Hon'ble High Court of Sikkim to reach a wonderful last session of today's program. In this occasion, I, on behalf of Sikkim Judicial Officers and on behalf of all officers present here, physically as well as through virtual mode, would like to extend a warm welcome to His Lordship. And we are extremely grateful for being here in the benign presence of His Lordship to do the honor of last session of today's program. As a resource person, I once again welcome Your Lordship and request Your Lordship to kindly guide and lead all of us present here on two topics of today's last session. Thank you much.
He didn't offer me. That's why I thought it was nice. Today is land laws, isn't it? So let's change this thing of it into a more interactive session. What are the issues that you all faced during the trial of civil cases with regard to land? And what are the issues, what are the issues, what are the laws that are involved, and how do you deal with it? So let's reverse the talk from that side to this side. Let's start with the civil judges who are doing trial cases. If the senior civil judges start talking, maybe the others will follow. Yes.
Good afternoon, Lordship. Lordship, in the morning also we were talking about it. We were facing issues mainly with regard to the identification of plot numbers as it stood earlier in the 1951-52 survey, and later on which were renumbered in the survey of 79-80. And they were telling us of the process in which
They means the previous.
the revenue surveys is the practice that they followed. But then they were also, they said that normally Amin and the head surveyor and the inspector are the ones who go for survey, but then we were saying that in most of the cases that we have seen, it is only one person who goes for the survey, and they were saying that they are supposed to be present. So we were asking whether there is any kind of a rule or mandatory law that requires all of them to be present, but then they said that it was all a rule of practice only. So that is the main issue when it comes to the validation of a document when the reports are also prepared by the survey, anyone. They say that the argument in the court is that it is not valid because it is not signed by all the persons present and the boundary holders also. So they were saying that it is not mandatory, but then it is as a rule of practice that they ask them to be present during the spot verification.
So this question which you asked about rules, whether rules being valid, who did you ask this?
The deputy director and Mr. Revenue Officer.
And the answer to that was they don't follow any rules.
They don't have any set rules, mandatory rules, but then that is as a rule of practice.
But is that correct? Is that correct? What are your views? I'm talking about all the judicial officers. Is that correct that there are no rules? How do I address that side of the border now? Are you hearing us? Are you hearing us? But I can't hear you. Unmute yourself.
I can hear you, but occasionally it's the line is disrupted. Otherwise, it is clear, and I can.
Okay. So is this the view? Relate to you all also in the courtroom that there is actually no rules and regulations to guide the surveys and the settlement and the making of the parchas and the Khatiyan? Registration of document rules. That's your guess. Okay.
Sikkim record writing and attestation rules 1980.
She's the smarter one. Picked it out from the Okay. So there seems to be a lack of coherence and an understanding of how these things are. It happened to me as well. And I think I relayed this story to you earlier, and how I chanced upon this particular 88 rules. My father would tell me that the survey and settlement happened in 50s, and at that time there was the Kotakunnu rules of 1950 or whatever, and because of that particular rules, survey and settlement happened, and purchase and Khatiyans were prepared, and we were going according to that. He continued saying this for a long period of that time, and I continued believing that because I thought my father was an authority in this kind of things. So I went on with this belief that it was the Kotakunnu rules that would control this kind of preparation of Khatiyan and parchas. In a proceeding which came to me, a writ proceeding on the 227, they challenged the order of the executive magistrate, saying that he did not have any right to go into a civil dispute, and therefore this order is wrong. I found it interesting. You should notice during the proceeding I also got a chance to ask the DC, was also a party to that, as to how did you do this? You passed an order, certain civil rights have been examined, you've led evidence, and you passed certain orders which affects the civil rights of a person. So how did you do it, under what jurisdiction did we do it? An affidavit was filed that we did it because we did it. I wasn't satisfied with that kind of answer. So I said, I probed further. I said, let's examine further. Tell me what law did you follow? 3 adjournments later, an affidavit was filed saying that the Kotakunnu rules of 1950s has been done away with, has been repealed, and in place under the Land Reforms Act of 77, the record writing and attestation rules of 1988 has come in place. But the learned DC in his affidavit did not answer the most pertinent question, that is, which is the law that you follow? Because unfortunately, he also did not know the existence of this law. On the side, the learned counsel representing the party told me that it was at his instance he probed further, and this document was obtained from the files of the government, and therefore he is filing it. So the government has it in his record, no prachar about it, nobody seems to. The end result is this: the entire judiciary is absolutely unaware of how things are supposed to happen and how things are actually happening. How things are happening is they are following precedents. Mero predecessor did this, and I will also do the same thing. So it is going on and on and on. Some of them are right, because the earlier person perhaps followed the Kothapur rules. So many of these practices perhaps would be similar to what it is now, because it's the same kind of procedure, isn't it? So on a first glance, it may look as if they have followed the law. But if you look at it in a closer scrutiny, you may find something completely different happening. You understand? When a legislature makes a law, it is to be followed. Right? There is some kind of thinking. The presumption is the one who made the law knew what they were making. So if they knew what they were making, then we need to follow it, isn't it? The people need to follow it, the officers, the executive needs to follow it, and we need to decide based on that. But I have read so many judgments. Never have I come across any mention of the record writing rules of 1988 till now. From 88 to 23 is a long, long time. Have you had any occasion to deal with the 88 rules? What about the West? See, so how do we now, I don't want to give a lecture on the 88 rules. You have to come out and devise this way of dealing with it. How do we deal with it? The law is in place, the executive is not following it, in turn, in court, nobody places the law. So the judicial officers are also not aware of this law, because it is not placed by one side, other one doesn't argue it against, and therefore there is a blank. How do we deal with a situation like this? In the same breath, I want to put another situation. And I've been mulling over this issue. We belong to different communities in Sikkim. The majority of us perhaps belong to the Hindu community. But then there are other communities as well, isn't it? Now, while the question of various Hindu law concepts, the question of ancestral property, according to me, is a Hindu law concept. Now, in the rest of India, when we talk about a Hindu family and we talk about an ancestral property, obviously the judgment will follow the Hindu law, and then we will write our judgments. But when an issue is brought up by a Buddhist, by a scheduled tribe, about an ancestral property, how are we examining this concept of ancestral property in that situation? How are we then bringing in the Hindu law concept into this situation? As we know, and we have been told again, that each of us have our customary rights, the customary laws, and we follow that, isn't it? Now, I have not been told that ancestral property is a concept of the Tamangs, of the Rais, of the Limbus, of the whatever community. But then we have been writing judgments on ancestral property, somebody is claiming ancestral property, and we give a declaration that it is ancestral property. It is not ancestral property. Following a Hindu law concept, there is judgment of the Supreme Court which defines this. But how is it applicable? Are we applying our minds to that? This is something that worries me. Maybe it is applicable. I'm not saying it is not applicable. Maybe it is applicable. But why is it applicable is something which only we can answer. Nobody else can answer that. So how do we deal with that? It is the same line. Parcha Khatiyan is placed, you are giving your judgments on Parcha Khatiyan. No issues are raised by either side. In the High Court, when this issue came up, I threw my knowledge. But in Sikkim, we have the Kothapur rules. When I said that, they sought an adjournment, the Learned Council. They came back next time, and all of them were absolutely, on top of their game. One wanted to show rule so and so of the Kothapur rules, the other wanted to show another rule and their interpretation on the Kothapur rules, and there was a huge number of issues drawn and arguments happened with regard to Kothapur rules, to be told on the next occasion that Kothapur rule doesn't exist. I'm sorry, I'm being very frank with you all, so that we discuss how to resolve this. The learned director made this compilation. Day before yesterday, I looked at it, and all that I see is Kothapur rules out here. So I asked the director, what lecture am I going to give on Kothapur rules, which does not exist anymore? How do we deal with this situation? Please help us. I want your views. Unless you talk, unless you mull over the situation, we can't resolve it. It has to come from you. It can't be coming from a lecture by you. So how do you deal with it? Please start. One of you have to speak.
Maybe the executive magistrates will have to be made aware of this.
So we make aware the executive magistrate. No, today I am not dealing with executive magistrate. We have to deal with our situation. A suit is filed. Right? Now the jurisdiction is ours. How do we deal with it? Give a direction that the executive magistrate needs to know more. We can't do that. Right? When I say we, I'm talking about as civil judges, as district judges. How do you deal with it? As I see across India, we are the most backward state insofar as land rights are concerned, land records are concerned. We are extremely backwards. When executive who are involved in the process are not aware of what is the law that should be guiding them and the process as per the rules that needs to be followed, I don't see it going anywhere else. It has to be backward. But now the situation is that these matters are coming up before us. Each of us in our respective jurisdiction, we are hearing arguments and rendering our judgments. Based on what? I don't know. Facilities all work.
So, I think,
yes.
if I may interrupt.
Yes, of course, not interrupt, interact.
Yeah, so now that your Lordship has brought to focus these issues, I think a step forward would be to, get all the revenue to undergo extensive training on these issues and going to like these relevant rules so that the next time any case comes before civil judges or just judges, we can raise best. And then thereafter, ever goes through the Honorable High Court, then you are thereafter lay down the procedure.
No, but that's right. That's a long-term plan. We need to do that. But it is not stopping the people from filing cases in your courts. You are deciding civil suits every day. So how do we deal with these situations? The executive let us presume that the executive doesn't know the law. But Parcha Khatiyan is prepared. Parcha is prepared, Khatiyan is prepared, it is brought before us. Right? Revenue records are brought before us. And we are dealing with it every day. Right? It's not only the Hindus who are filing suits, everybody is filing suits. Right? The lawyers have this particular knowledge. They learn about a Hindu law concept, apply it to the Bhutias. It may be applicable, but how is it applicable? Why is it applicable? There must be a clarity of thought there. But so and so is fine.
We must not
Yes.
that we also have our own laws because of which Sikkim again stands at a very unique situation. Where
Exactly. That's right. Absolutely right. So we seem to be giving a go by to a lot of things by just reading some judgments and understanding that I've understood the law. The lawyers are thinking this way, and therefore they are filing a case. I have seen cases, and I have also dealt with cases. I think one of you must have dealt with that case, which is now pending before the Supreme Court. Very unique case. Ancestral property, I don't know, adoption, every issue is raised in that. By most probably a Tamang who's become a Christian. The pleadings does not even suggest that the person is from a particular community or follows a particular religion. But the affidavit filed along with says I am a Christian. How does the court go into the question of these ancestral property, adoption, without understanding whether adoption is valid, whether a concept of ancestral property exists in that community? It's a question I ask myself. So how do we deal with this? I don't know. Or is it, I don't know, am I not understanding it? Is it generally that every community has this concept of ancestral property? Every community has this concept of adoption. This recent debate of uniform civil code is going on right now. The entire debate hinges on this issue of customary rights and practices, isn't it? If every community has their own customary rights and practices, which the law and the constitution recognizes as good law, then where is the question of uniformity? Political debate will go on, but then we have to apply it in our everyday dealings in the courtroom. So how do we deal with it? Would I be asking too much if I were to ask each one of you, when a matter comes up of this nature, do you question it? And I want to understand your mind. It's all right if you don't question it. But do you question it like I do, or am I just overthinking? When there is a plaint filed by a non-Hindu, and he talks about certain concepts which are akin to a Hindu law, like property of HUF. undivided family property. I've always understood as a Hindu law concept. Now, how is it arising in a Christian situation or a Buddhist situation? So when a Buddhist, a scheduled tribe, comes to the court talking about ancestral property, do you question it? Because if you don't question it, then you will not get the answer. The right question will get the right answer. But if you don't question it, then you can't get the answer. You need to question yourself. Then you will be inquisitive to know how is it happening. Maybe what Justice Pradhan said on that day was absolutely wrong. But you need to question it. I'm trying to provoke your thoughts. Are we dealing with matters the right way? On the one hand, we have had a number of these sessions where we talk about customary law. In the last occasion, we talked about marriages, if you remember. And I've shown how marriages in Sikkim, especially the Buddhist and the Christian, have suffered in Sikkim after the advent of Hindu law in Sikkim. All of you got married under the Hindu law and registered under the Hindu law. And the courts are now not granting divorce. Look at the ridiculous situation that you are in. Because one officer down there in the registry, or what do you call it, the DC's office, read the first part of the section, section 3 if I am not wrong, to say that the Hindu Marriage Act applies to Buddhist. So he gave an order. And every person followed it, including some of us. Right? I'm glad all of you are happy. If not, what do you do? Now, one case came before me, the first thing I saw is the name. I'm a curious judge. When I saw the name, I said, divorce under the Hindu Marriage Act. I said, how is this applicable? Then said, no, it is the Buddhist. So I said, how? Read little further. The other part says it's not applicable to scheduled tribes. Oh, I am enlightened now. Now you are enlightened, the lawyer is enlightened, but what happens to the poor fellows who came before you? How do you deal with that situation? See, this is the same issue that's happening in the land records as well. How do we deal with it?
I think as judges, as trial judges.
Come this side, please.
As trial judges, what we can do is, at the inception itself, when the cases are filed.
Are you all hearing?
Yes.
When the cases are filed.
They're not hearing. I think you need to come closer.
Just my opinion is that when the cases are filed, what we can do is, if there is apparent inherent error, for example, the filing of a Buddhist filing a divorce case, or if there is some land revenue rules which is not followed at all, what we can do is we can return the claim and ask them to correct it and bring it, so that thereafter there will be this kind of precedent. Otherwise, I think they're going to have the same thing repeated again and again.
Don't you? Do you all agree with the suggestion?
Because we are not stopping somebody from bringing the case, we are just returning it to cure the defect and bring it back.
There is, the apparent, what I see is there is apparent lack of knowledge. We are not questioning, the lawyers are not questioning themselves. We just follow. Ule pani pass of order. Open by. See, I mean, we follow a very uniform thing out here. We are all equals, and that's a very great thought. All of us are equals. So our lawyer treats a Bhutia man and a woman, and a Hindu man and a woman, and a Christian man and a woman as equals. That's a very good thought. But then, are we really applying the law? So Don't you think this would be the right way to deal with it? Which again brings us to a very fundamental thing, our own knowledge. It is time that we uplifted our knowledge base. At least our local laws, we should know. Why are we lacking in our local laws? Let's understand this issue. Why are we lacking in the knowledge of our local laws?
The first thing is availability of these local laws.
Correct. Non-application by the executives. The 88 rules were confined to the files of the government for all this period. The executive magistrates, however, thought it fit to be the judges that they are and decide the cases as they so desired in their way of thinking, that I did justice by listening to both the sides, making them file their pleadings and then taking a call. Equity and good conscience. Equity and good conscience is very good for the olden days. Today we are guided by law. That is law, rules, regulations. We need to follow them. When rules do not exist, equity and good conscience must come in. But when rules are there, can't ignore that and equate. Then we are doing what the king did. It was very equal. We are doing exactly what the Darbar did. We are doing exactly what the Diwan did. And we are doing exactly what the political officer did. And that is taking us back to 1889, by the way. And then we are going back to the time when we all started it. We're going to the museum. The first chief judge of ours came to Sikkim in way back in 1907 or 1908, Rupnagar. He became the chief judge in 1916. That was the time of Adda courts. Landlords became judges. They did not know the law. The English-speaking one was the presiding officer. They rendered justice. No rules to follow. Only thing that would follow was equity and good conscience. Today we are in 2023. The constitution is in place. Rules have been made. I remember way back in 2006. I was sitting in my chamber, a political client of mine came sometime in mid-May and gave me this huge file. Put it in front of me. I said, what is this? He said, this is for you to read. This is the law made this year by the state government. Yes. So we have these piles and piles of law that has been made. We are not aware of it. Executive is not aware of it. It's not applied. And therefore, all of you are doing good judgment. It's good. It's right. You know, when the law is in place, then you have to use your good conscience and all that. When the law is in place, then when we are not interpreting the law, then are we going right? Again, there are questions thrown to you. Let's start from the youngest. What do you think?
Lordship, I think the first thing that we need to do is to find out as to what are the laws, the evolvement of laws, what are the laws governing the area, and then like bit of research and then decide as per, even if there is no precedent to follow, we decide as per those laws.
But the vital thing is to question it, isn't it?
Yes, Lordship.
Am I trying to turn everybody like me? I get worried sometimes. You know, I have this terrible reputation in court. in a simple matter, I make it complex. And am I turning everyone like me is the issue which, again, you will have to deal with. That's why I'm asking you, therefore I put a, protective area. In fact, I wanted the senior most judge to be here, to protect me. But she's there, so far away,
But Gautam, I think I'm as if not more helpless than you. Because we are floundering given our present circumstances.
I know, but then we have to get out of this, complete vacuum as I see. We are rendering good judgments. And I dare say even the High Court, in many cases I've seen, have decided cases without the necessary pleadings with regard to other communities, applying Hindu law concepts. It could be applicable because if I were to go further, I had the occasion to read the draft customary rules of the Bhutias and the lepchas. Many of the Bhutia lepchas are following the Hindu law. But that is a customary practice. Whereas the Hindus are now governed by a statutory rules, law, or the old law which has been followed over a period of time. We don't have the same thing in the other communities. But the customary law has not evolved in Sikkim. So what I see is that our judges are taking their personal knowledge or whatever and applying it to the facts of the case. Yes, in the Bhutia community also they follow that. So when a Bhutia is saying that it is an ancestral property, it is ancestral property because they are following it. That could be the only way to deal with it, isn't it? But then there is a huge difference between how a customary practice is proved in the court. Even if you see the old judgments with regard to the Hindu law, when we are not codified, the Hindu law was not codified, and we are following, our customs. The judgments, if you see, especially the trial court judgments, is how these customs were proved in the court. Then they went to the next stage of making it statutory law. Sikkim, however, is stagnated. Am I right or am I wrong? I don't know. Please tell me. As far as Hindu law, if you go to the rest of India, Hindu law at one point of time was, isn't it, was customary like any of us. We followed that and we, by practice, so a woman would not get right over ancestral property. The old law said that. The Dayavaga and the Mitakshara, now we have codified, now we have given certain rights, right? That is not applicable in Sikkim, that's another different, is a different thing, except by judgment of this court. But as far as the scheduled tribes are concerned, right, how has the law evolved? Let's discuss that. Is there any precedent of, sorry. Yes.
Sorry to interrupt.
No, please. I want an interaction because I'm equally confused and I'm trying to confuse you so that I get more knowledge.
So, Lordship, I just want to mention a matter that I had some years ago, where the issue of adoption also came up.
Yes.
And so, to prove this adoption, because they were from a scheduled tribe, I turned to see what was the custom for adoption. So to prove that, I was looking into the evidence, but it was so difficult to extract that customary customary law regarding adoption, because there was no such specific customary law for adoption. From what I could gather from the facts and circumstances and the evidence adduced in that case. So I did attempt to try and give a finding on the adoption being accepted as customary, because by and large, because the child also belonged to the lecture community.
Yeah.
So there was no problem. So it was accepted as adopted. The son was as adopted, and that was finally how the issue was settled. But then these are the difficulties I think we will
judge
face.
faces.
Yes, Lordship, because there is no specific customs I find for such things as adoption in the lecture community or adoption customs regarding.
How are you saying that you don't find it?
In a sense, Lordship, because they try to get some material on they try to consult the elders, but there was no specific customary law laid down in the communities, Lordship. So whatever was gathered by word of mouth, that was what was the evidence given. So I do not know if they ever went in appeal, because nothing came back after that, but because I was hoping that something would come out of it. I would learn also.
I have a little hesitant, but the problem is not with you. The problem is the person who's filing it. The
Yes.
knowledge has to be there. I have had so many talks where I have told the learned advocates that as far as customs are concerned, you need to prove it. But it's not taken seriously. So they will file cases and then we go on our presumptions. So the learned judge is being the plaintiff's lawyer. That is what I see here. The learned judge is to decide on the plaint, but instead now she's trying to see how to get it out. The getting out is by the plaintiff, isn't it?
Yes, sir.
So again, I fall back to what Mr. Karma said. Are you pleading this case under the customary law? Is a question which you need to ask. And if you ask the right question at the very inception, maybe the lawyer would be a little wiser and say, I want to amend the plaint. And then they will use the CPC to do the needful. But if you allow the plaint to come in, and the written statement to come in, and then the issues to be framed, and then the trial to come, and in the end of that question, you're back to the same game. I think it is time that we ask the right question at the right time. And I agree with Mr. Gompo that maybe this would be the right approach. Because we have been giving lectures. I want to give lectures, but nobody wants to listen. We've been telling lawyers, let us organize it. The whole executive came the other day and I was talking to them. And then the director, it seems, told them that we have given you 3 occasions, but if you're not going to come, we're going to cancel all that. This was promptly relayed and the executive got into action. They made a list on their own consent. The lawyers gave a list. There were about 27 of them who were willing and ready to come and hear the lectures in the Judicial Academy. On that day before, it seems, all of them backed out and there were only 6 left. So the executive were hesitant to tell the director what now. We are in a very precarious situation as I see. And this is only east. Unfortunately, the north, west, south is not even, privy to any of these lectures or has occasion to come down to hear the lectures. That's why I've been telling you with regard to organizing it in Gazing itself. So we take the Judicial Academy from here and go to the districts and do it. We have to do this reverse situation. Otherwise it will not work out. It is not happening in the East.
Once the roads conditions are improved, I'll definitely...
we have to do it. We don't have a choice. And I leave it to you to drag all of them down. You use your whip and... we have to force it down their throat. It's, I don't know. It's a very frustrating thing for me when I don't get answers. I can give lectures and lectures on this. What is the point of giving lectures? I don't understand. The application is not happening right from the grassroots. Where it should start, it is not happening. They don't know, lack of knowledge. It just then goes up right up to the trial. In the end of the trial, we start questioning, what's the point? There is no evidence. Then again, it's equity and good politics. Good judges. I am assured all of you are good judges. How do we deal with it?
It may not be in the context of the judges, but this is only my opinion. Many of the cases that comes to the court is based on customary law, like Madam said about adoption. Many on marriages, because we have a peculiar situation in Sikkim. There are a lot of tribals who don't follow the Hindu law. We have our own customary law, but how do we prove custom? Because the older people are now dead. Now the younger generation don't know what their customs are. So it is not the courts, but there has already been a study of the customary law of various communities in Sikkim. The Bhutias and Lepchas, for all of them there has been a study.
Yes.
And I have read the customary compilation of the personal law of the Bhutias and Lepchas, which is, I think, quite all right. If it's agreed, it's, as I said, not our concern, but the state. If all communities, after they see that customary law, whether the study is proper, if that is codified, I think the majority of our problem would be solved. So far as adoption, marriage, and a host of other things are concerned, because these studies, 90% is already over. Right? All that is required is that 10% will to codify it.
The two issues, as I see, as far as what you are saying is, as far as the Nepali communities and the diverse Nepali communities are concerned, that has been codified, and it's a complete thing. Codified in the sense, it has been published by the Law Commission and all. But as far as the Bhutia Lepchas and I think, I don't know, Tamang, I don't know, I'm not mistaken. Bhutia Lepcha and something, not Bhutia Lepcha and something else, it is in the draft stage. The two question that comes to my mind is, can customary law be codified? And what happens to, if it is customary law and codified, then does it remain customary law? But that is the job of the legislature.
Yes, as I said, it is not
our space. So how do we deal with it? As of now, if there is, according to me, a Bhutia filing a case of this nature, where it involves some kind of customary practice, then it is, I think, incumbent upon us to ask the right question to the lawyer at the very first instance. Are you trying to prove this by way of customs? If so, what is the evidence that you are leading for this? Because they don't know. In the, while you are not sitting as judicial officers and you are outside and you're giving a lecture, if we have the knowledge, we can guide them all the time. Customary, there are a number of judgments of the Supreme Court which lays down how customs are to be proved. I gave that in the previous occasion in the compilation with regard to law of marriages, if I am not mistaken. So we can use that, tell the lawyers that if you are trying to prove customs, then it has to be proved in this manner. Then if you ask these questions, maybe they will file an amended list of witnesses. As Mr. Karma says, that many of the elders in my family, my or the particular person's family is dead. But then customs can be proved from an elder from another family also. From the same community. That is how the entire thing has been written. So, but then, what I think I heard from one of you is that it's a saro lamo procedure. It's too long. अब कहाँबाट ल्याउनु कुन चाहिँ मान्छेलाई ल्याउनु के भन्नु लाउनु त्यो मान्छे इज नट इन्भल्भ विथ माई केस आएर के भनिदिन्छ दिस द वरी अफ द लयर हो अन्त किन यस्तो टाउको देखाउनु बरु छोटोमै लेख्छु अहिलेसम्म दिँदै राख्नु जजले दिँदै हाल्छ अर्डर द्याट सिम्स टु बी द अप्रोच तपाईँले क्वेसन गरिदिनु भयो त चल्दै जान्छ त्यही चलिजान्छ अन्त मेरोमा आओस् बेगपी अब म टाउको बनाउँदा आई हेभ दिस टेरिबल ह्याबिट कसरी रिजल्भ गर्नु त्यो प्रब्लम मैले चाहिँ मेरो आफ्नो दुःख पोखाउन तपाईँहरूलाई सिकाउनु केही छैन मेरो हाउ डु वी डिल विथ इट इज द थीम अफ माई talk today. You are almost asleep. Oh, very tired. What do you want to?
No, I was thinking about this particular case which I have.
Okay.
In this case, she's from a Bhutia community, plaintiff, and the plaintiff says that she is the daughter of her father, and from the second wife, because the father has not accepted her as a daughter. So she is saying that I'm daughter of my father defendant, particular defendant, and she is saying that I was born from his second wife. And she is saying that even I have equal right to the ancestral property, and also COI also from my father. So then I was thinking because of what you said, I was thinking because now the issue of ancestral property has come up, so should I make an issue saying that for the party to prove, for the plaintiff to prove what law is applicable to her?
You must answer that question yourself. I am provoking your thinking.
So that's
I'm not giving you answers. I can't give you answers.
That's what
All of you are learned judges. But are we thinking? That is the, what's important is to think. Then you will get the answer. It's very important to think. If we make a mistake, it will be corrected. But just think right. Let's start thinking. Before we apply, just think. How? Ask. Question. I think it's very important to just keep provoking. That's what I do in my courtroom. I keep provoking the lawyers. They get harassed. Some of them don't want to appear again, but they get harassed to the extent that they give me the right answer. See? Ultimately, I get the right answer. I get satisfied, I write it up. That's what I've been doing. I can't create evidence, can I? I'm a judge. It's impossible for me to create evidence. If it doesn't come from that side, I can't just write judgment based on my knowledge. I know my father told me that, my grandfather told me that. I can't write. How do you? Now this you cannot keep on. This is supposed to be a lecture on this. I think it is time for us, I can give a lecture this week, that we all read the Sikkim record writing and attestation rules 1988. It seems fairly clear to me what it is supposed to do, what the people involved are supposed to do, and how they are supposed to deal with it. If they have not dealt with it in that manner, then you know how to put the consequences, isn't it? But awareness of the law is important. I am worried that we will continue following Hon'ble rules. But I want to discuss this issue with the senior judges. The Hon'ble rules went away in '88, right? As I see and gather information, although I don't have any concrete knowledge about this, the '88 rules have been confined to the files of the executive for all these years, and none in any of the 4 jurisdictions has followed it.
Probably because the earlier resource person, they were also not there.
That's what I told the director. While you have brought the 2 resource persons, I want the senior judges to be there so that they are guided properly. Otherwise, the younger judges will go astray because they will say something and you will follow that. Yeah, हाम्रो Judicial Academy दुईटा on our resource person ल्याइदिएको थियो मलाई यस्तो यस्तो भन्यो लु त्यसको आधारमा जजमेन्ट लेखिरहेको छु and terrible judge in charge. He should be thrown out. So I cautioned the director, please make sure that the senior judges are there to guide the session.
Lordship, talking about awareness, I must make a confession. When I was a very young civil judge, Lordship, I was deciding a case between 2 parties. One was a private individual, the other was a committee representing monastic land. And then one of the issues framed as usual in a routine manner, I'm sure, but was the question of limitation. And my finding was that the suit was badly barred by limitation. But here, later, many years later, Lordship, I come across a document which is an old law which was issued during the Chogar's time. Monastic land limitation, the question of limitation will not apply to monastic land or something to that. Much my horror, Lordship, that was what I discovered. So,
Okay,
that is
that's
why,
right. This is a problem as far as Sikkim is concerned. You're absolutely right. I mean, there is total lack of knowledge. The law department way back in '77 came out with a compilation. Much later, another 4 volumes came. My father, when he prepared that, was of the view that everything is there because a group went to your house, a group sat in my house, group went all over the place and compiled all this, and they thought together that I have now completed this process. Then, a couple of years later, 4 more compilations came. But much to your amusement, in another case which I dealt with recently, I was shown a document. I was told that this document showed the law to be such in that manner. I can't go into the details. However, that particular document had the year, and it was signed by a particular officer. Thank God I had that little knowledge that that post was not in existence when this document was set to be written. So I said, the man came 30 years later, you're doing a document signed by that person 30 years ago. How is this possible? But the authority believed that this is a correct document. And they referred to and relied upon in the High Court. So you see how important is the knowledge you must acquire with your own history. It's very important. Please visit the museum, all of you. Not once, twice. You have made an effort to collate all this material and put it in place. That information perhaps would help you on understanding. Because what happens is, there is very few information left. It is scattered all over the place. The first compilation made by the Law Department in '77 was the effort of a collective set of people going into private collections. One of them is your senior district judge's house. It was extracted from there. But was it a complete one? No, because several years later they came out with another set of 4 compilations. And then once in a while I get to see few documents come like this also. So if I did not have the knowledge that the authority did not exist at that point of time, I would have rendered a judgment based on that. While dealing with land laws, in many of you deal with this situation of what do you call that 500 times, what is it? Penalty of 500 times for validating. You read many of our judgments also. Unregistered document. This, I want to throw this question to all of you. The first document of this series is a 28 document, 1928, which was amended in 1942. So that second portion of that provision, which was in 1928, was amended in 1942, and we are interpreting the amended one. The first paragraph of the 1928 and the second paragraph amended by the 42 document. But if you look at the 28 document, it refers to the old law of registration of documents. I'm just saying it off the cuff. I don't have this document. I don't know whether it is there or not. But it refers to an earlier document which is supposed to be our document rules, registration of document rules. Which means that prior to 1930, that's the registration of document rules 1930. You are all aware of the registration of document rules 1930. So remember 28, 30 and 42. 28 refers to an earlier registration rules. Has any of you seen this? You have not seen it. None of us have seen it. Correct? This is my thought. It just, I keep thinking, so I must throw it at you all. 28 deals with and it amends the old law with regard to registration of documents. Correct? Now, between 28 and the time of the amendment in 42, the new registration of document rules comes in 1930. In my limited understanding of how laws evolve, if a new law comes in, what happens to the old law? It ceases to exist. There can't be two laws operating in the same field. So the law which we have not seen, which existed prior to 1928, to my mind, ceased to exist when 30 came in. Right? If that is so, what was the need for an amendment in 42 then? Then the 30 rules should have incorporated 28, but 30 rules did not incorporate 28. So let us presume for a moment that it operated in two different fields. One dealt with the importance of documents and the validation of it, and the other dealt with the registration. That is the only way to deal with it, to bring some kind of coherence to this issue. But what troubles me is we are examining the same issue again and again, oblivious of what happened earlier. So our judgments are silent about the past because we don't know the past. 28 refers to a document which the state does not give it to us. My dad did not give it to me. None of us gave it to you, so we don't know. So how do we operate in vacuum like this? There has to be coherence in the law. I find it a very chaotic situation. It's time I think we took a step forward. We need to think.
Can there be one solution? Not to this, but all these laws, what we have is, it has been compiled into volumes. Volume 1, 2, 3, 4. And if we start reading one volume, the subjects are all scattered. Basically, one animal husbandry, suddenly it goes to another, suddenly it goes to another subject. Can there be a compilation subject-wise? Or, because
somebody must do it, right?
Yes, 70% is not relevant to what I want to find out. So, there could be some review on land laws. This is also taken out from these older field records. Some of these important.
But what Mr. Karma is saying is absolutely right, but this is the job of the executive. The state government will take stock of the situation, understand it's a pressing issue, and deal with it. In fact, a commission should be set up, and the commission should be authorized to go into all this and sort this law out. Otherwise, what is the point of dealing with it? You write a judgment based in two notifications, third notification crops up, which changes the scenario completely. And we are so conscious and so protective of our own laws. We don't want to budge. And we don't know the old laws. We don't know the old laws. I'm telling you, I have not seen any judgment which talks about the law which is talked about in 28. Neither from the district court, nor from the high court. So where? How? When is the question? And who's going to provoke this? It has to come from all of you. Take it upon yourself to understand this and push it. Express it. If you push it. Yes.
In fact, what I was going to suggest to do some work on this limited knowledge budget.
No, you can't. As judge, we have no choice. We can't be wary. We have to interpret it. They produce it. We have no choice. So to interpret the law, what do you do? You can't run away from it.
So the law commission can do some study on it.
That's right. But
at least we have something.
I wish the law secretary was there. There is no PI pending before me so that I could write a judgment. So how do I, on what authority will I say anything? I can just talk. I can tell all of you. Tell your colleague. Take it up. Do it. It's a pressing issue. It's a vital issue.
We didn't even know about the existence of Sikkim motor vehicle rules in Lordship in one of the judgments under 2019-20. This
It came from the lawyer who's no more, God rest his soul in peace, but he brought this issue up. The case was filed by the lawyer, and then he showed me the provision. The provision was showed to me by the lawyer. I read the provision and I found that it said, if the rules are not in place, then the judge must do what he has to do. That was the common substance of that. So the first question I asked the lawyer, is this law there? He didn't hesitate. He showed it to me immediately. Then he said, how is this judgment there then? You are the trial court lawyer, you are the appeal court lawyer. You pulled it out immediately. Why didn't you show it to the learned trial judge? All that I got was a smile on my face. See, the thing is, we need to be up to date. This time, my earnest request is, push the boundaries. Push the boundaries and get more knowledge. Keep it. I take this thing to make this compilation and keep giving it to you with the hope that you keep it and add on it and tell me this is missing here. And then, make this compilation better. This is my earnest request to all of you. It is time we got out of this darkness. We've been applying the Motor Vehicles Act for a long period of time, and perhaps the newest judge which has come, except the younger ones out here, all of you are much senior to me. 6 years old. The courts have been in existence for a long time, isn't it? We have to provoke ourselves first. We need to provoke the lawyers, keep provoking it. We are in a different situation. In any other, I've been in the Supreme Court, I've been to the Delhi High Court, I've been to different high courts. The level of, unfortunately, as I say, the lack of knowledge is more here. Because not only of our ignorance, but of the non-availability of information. The non-availability of information is huge in Sikkim. Gazette notifications. The laws are printed and published by the Gazette section. Pray tell me how many of you honorable judges get a copy of the Gazette notification? You don't. Pray tell me how many of you seek the Gazette notification? If the honorable judges are not aware of the law, then who will tell the litigants that this is the law? I'm sorry, I'm very blunt, but this is how I am. How do we get out of this darkness is a question each one of us sitting here must answer to ourselves. I have this terrible habit of sermonizing my thoughts. I do it in the courtroom, I do it here, I want an interaction, none of you are talking, so I have no reason not to do so. You must be waiting and looking at your watches. Stop. But come on, let's interact now. How do you do it with it? You tell me. You've woken up from your slumber. You're only pressed with your issue, but I want you to understand the general issue that is, keeping us so much in darkness. Take us out of this slumber.
Like you said, the only thing which we can do is gather information, gather knowledge.
Correct. I'll tell you a trick. Okay? We have this hesitation. As a judge, we have this hesitation to show your ignorance. I'm telling you, isn't it a basic thing? It's a human tendency. We are hesitant, we are afraid, we are scared to show our ignorance. And therefore, you are hesitant to ask a question which is in your head. La, royalty, Mohammed Sane ho, eligible. Senior Victoria. अब सोधु कि नसोधु, बस भन्नुहोस् यसो कि if that happens, we somehow fail. I came very openly to you and say, I don't know, I don't have the necessary thing to, I am knowledgeable, I am not knowledgeable, I don't know. This 28, 42, 30 is a question I asked myself, this is about 3 months ago. I've been lawyer for 27 years before I to judge. If this is a question which is coming to me now, all of you are younger than me. Senior judges, but younger than me. Except what? The senior most members. We need to ask the right questions. This is for all of you. Even at the cost of your own pride and ego. Please ask the right questions. You know, I've been doing criminal law for a long, long time. If I can fairly say I have gained some amount of experience, it is in the criminal law field. But every time I read your judgments, I am faced with a situation which I have not dealt with before. Every time an appeal comes before me, I am questioning my own knowledge. This is something which I did not know. That's the vastness of the criminal law, jurisprudence. So if I can say I do not know, I'm sure all of you can say it. I think humility is a hallmark of a good judge. We are not here to dictate and rule. We are here to do justice. To do justice, we have to throw this chair and sit on the floor amongst the people. Get knowledge from them, get knowledge from any source that is available, and render judgment. It's my personal thought. You may have a different thought. It's my personal thought. Maybe I'm a little mad. That's how I feel. And I think it is important for me to tell you all this. Keep your egos inside you. Keep your feelings of, discomfort inside you. When you are in the courtroom, be focused on resolving the issue before. For that, if you have to stoop, and plead your ignorance, if you think it is stupid, please do. Ask the right questions. As rightly said by Mr. Kalman, at the very first instance, I feel that writing judgment starts from the time the complaint is filed. When the complaint is filed, when the charge sheet is filed. If you know what is the case, then you're top of it. Then you can't be misguided. Even the most difficult of the lawyers come to you, you know these are the issues, this is how I need to deal with it. I know these are the questions I need to ask. And this is the only way, I'm glad he's given us this answer. Otherwise, how do we deal with it? No, I'm throwing it to all of you to think whether I'm right or wrong. Am I thinking right? And the one hand I've been hearing from everybody, we have our own customs, we have our own customs. Everybody has. I thought Nepali had their own customs. But then when I look at that compilation, Nevarko custom, Kunigeko custom, Baunko custom, Gentriko custom, Kuniko custom, Bhakko, Nepal, Sabi Nepali, Sabi community, after custom. Kuniko custom, हाम्रो बाबाले भनेन कसरी डिल गर्ने अब we know some fundamental customs like marriage customs because it happens, keeps on happening, so therefore you are aware of it, otherwise we don't know. This thing of adoption, you know, if you look at the old laws, I mean, my understanding, the matter is pending before the Supreme Court, but adoption in the 1930 document, registration document rule, it says that if you want to register your adoption, you can do it. Why did anybody, I thought to myself, why did anybody think in 1930 that adoption should be registered? It didn't make it compulsory because the law was not for that. It is for the purpose of registration of it. Right? But it also had the 28 and the 42 rules which said any important document which the court considered to be important, so gave the discretion to the court. In 1930, it said that that document can be registered. In 1928 and 42 rules, it said that if it is an important document, it should be registered. Now, I'm thinking, when this law was made in 28 and 42, 28 मा हाम्रो कानुनी व्यवस्था के थियो? To ask this question, there was only a chief judge in the landlord's court. The Diwan's court came in 1954. The High Court came in 53. The High Court judge came in 53. High Court was created in 55. 1889, the political officer came. Then, of course, there was the King's Court. So, in 1988, in the executive area, the only court was the Chief Court. The Chief Court would preside over the 3 benches of the landlord's court. Each of these bench would comprise of 3 landlords, and the English speaking of the 3 landlords would be the presiding judge of that particular bench. They would render the judgment, the appeal would go straight to the king. So when 28 law came, which talked about a previous law for registration, and it was amended in 42, it gave the discretion to the court to consider whether that document would be valid or not, important or not, and if it is important, then allow the registration on payment of 500 times. To my mind, if adoption was thought of at that particular point of time, in the registration rules of 1930, a provision was made to register adoptions, and I think any court would see that it is an important document. So I have rendered an opinion which says registry must have been compulsory there. But the discretion is left to the court. Are we exercising that discretion? If this law and we are so protective of our old laws. Are we exercising this option? Or when this issue comes up, are we saying, yes, it is an important document before validation? I think we need to do that because that's what the law asks us to do. Are you all with me? Because you're looking very, you understand what I'm speaking in years. So maybe if you have not seen the document, I can understand. If you see the document, or did I have occasion to deal with it to you all? We have had a discussion. You know? So the registration rules of 1930 is a rule which is for registration of documents. It's called the registration of documents rules, right? In the rest of India, we have the Indian Registration Act. It seems, I'm ignorant, I have not seen, but the 28th rule, which is a very short rule, talks about an earlier registration rules, which means much prior to the 1930 rules. Okay? The 28th rules is only saying that all important documents must be necessarily registered, and if you desire, plaintiff or a defendant desires to use it in the courtroom, then you need to validate it by paying 500 times the registration fee. You understand? There has been a slight change in language in 42, but more or less it is saying the same thing. Right? So we have had occasions to deal with these two notifications and render many of our judgments on this and how to deal with it. Right? In the last judgment which I was talking about, I had the occasion to deal with the issue whether an adoption needs to be registered at all. And my opinion was it should be. The fact of that is my legal opinion. The fact of the matter is otherwise. How many families have you seen have adopted children without or with the registration of their adoption units? Tell me, in your personal capacity, how many adoptions have you known and how many of them have been registered? Zero registration. The fact of the matter is this: law operates in a completely different situation, you know. Sorry?
The girl, Barbara, she had to lose her job because of this adoption.
Ah. The reality is something completely different. At that time, there was nobody to guide. Today, we don't have anybody to guide. We've come a long way and not traveled at all. Where are we going is a question that the younger lot needs to ask themselves. Where are the time talking about it? Are we still going to plead ignorance? What do you say, Mahima? Are you with me or not with me? Okay. So what's your thought? I wanted to provoke a discussion, but then I'm just rattling away. Nothing there is. What? Come on. Your thoughts?
Like in our community, we have a customary way of adoption. I have audited and some of the community authors have written the procedure that are involved in the adoption. So,
who is somebody's written?
Yes.
Who's that? Where is that book?
J.R. Subba's book, which records the
J.R. Subba's book, what is it called?
History of some, I forgot the name, but he
that
records
was
them.
Recording
According to
that also
customary with regard to adoption, marriage, everything, yes, recorded it. So can we refer as an evidence when about questions of such, let's take for instance, issue of adoption comes up? Can we refer that book as?
No, you are talking as a lawyer, as a judge. We are talking as a judge now, no longer a lawyer. Why I ask this question? Because you've been a lawyer before. Okay? Yes, as a lawyer, you should. One of the way of proving customary practice is by authoritative text. Right? But here, the writer is also a liar. He can be brought in as evidence. He can give his oral evidence. He can say how he wrote his book, what is the kind of research that he did, and that can come in as evidence and prove that your community adoption is done in this manner. That's the right answer. But as a judge, how will you ask this book? This is the issue that was provoked by me, and the answer fell from here. If a plaint is filed before you and you realize that he may not, because he may not know. So he may not write that I am relying on customary law. We judges want everything black and white. Right? In many occasions, as a novice draftsman, we don't realize the importance of saying that I belong to so-and-so community. So it's important. My identity doesn't start from my community, it starts from me. I am Bhaskar Raj Pradhan. I write an affidavit, that's good enough. But if I am now trying to assert a right, then the first question that I must ask myself is, how am I asserting this right? Where is it coming from? It should be either a statutory right. Tell me any other way a right is asserted in a courtroom. Please tell me. Answer. One is by statutory. What is the other? Customary. Now, whereas a statutory right is there in the statute book, and therefore you can show it to the judge and say, here is the statute book. Right? Customary law, how will you? How will you do it then? It can be done only by asserting that I belong to this community. So, in a suit filed by the learned judge, if he was to file a suit, he will not only have to assert that my name is this, but he will also have to assert that I belong to the Limbo community. If you do not assert that, then where is the occasion for you to lead evidence? Evidence has to be led on pleadings. Whereas the judge, as a judge, I may know, you belong to the Limbo community, you belong to the Rai community, but is that good enough? My personal knowledge. My personal knowledge is not enough. So we are a very small community. So we think we know each other. That is the thought. That's neither answer. This seems to be our attitude. Time waste. So we don't write it. So in what jurisdiction are we going on that issue? In many applications, it may not be necessary for me to write my community. The fact that I am Bhaskar Raj Pradhan and I am a COI, we are very clear about this. I am a Sikkim subject. In every plaint, in every petition, every writ petition, I am a Sikkim subject. I am a COI. It's another matter that it is used interchangeably. It is not interchangeable. It belongs to two different domains. Right? But when we are asserting customary rights, the customs come from where is a question we need to ask. Is your custom same as mine? मेरो छोरीले बेलसँग बिहा गर्छ तपाईँको छोरीको बिलसँग बिहा गर्छ? किन बिहा गर्यो? बिलसँग बिहा गर्थ्यो? छोरी के भनिदिएको भयो? सिन्दुर लगाइदियो पनि के गर्यो? This is my custom. And the joke of this was when my daughter got married to the deal, I gave out a lot of cards, invitation, and a lot of people came, Nepali में लेके थे बेलसँग बिहा. Most of them thought मेरे छोरी को बिहा हुआ. Tiny little girl, 8, 9 years old, whole lot of gifts came. She was tired and really bothered that day of all this customs happening, crying most of the time. In the end, when she saw this whole set of gifts, she was so excited and they said, let's open it. We start opening it. Pressure, cooker, hot keys. You see, so sometimes customs does all crazy things to us. That's on the lighter side, but then you want to preserve your customs, then let's do it correctly, right? You need to stick your customs. Only what? Only who's me? You are telling me something which I'm not aware of. Because I have no occasion to deal with your community, or understand, or read this book. I'm glad you tell me. I want you to find out the name of the book and give it to me. Not the book, the author, so that I can get it. Or perhaps I had it. Just that you know. And then share it amongst others so that we can pick up these things. It's very important. This is the question I want all of you to ask. Each of us must ask. So if he's asking about his community, I think as judge we are entitled to ask about each community who comes before you. Let me be very clear. What I see from your judgments are very good judgments. That's a standard. All of you are right, very good judgments. What is lacking is, you're not questioning. You're giving the right decision, but the way you're reaching that decision is based on your knowledge, not from the facts of the case. I'm talking in a case of communities, in civil suits, because you're not dealing with that community. So it is, where is it coming from? Equity and good conscience and your own personal knowledge. I belong to the Bhutia community, yes, I know. So I'll give a judgment. It's a good judgment. Can't be wrong, you know it. But you are completely wrong. Because you have not left in your judgment any trace of that knowledge. It is like rendering a judgment of 40 pages and not giving any reasons. Or rendering a judgment of one sentence without giving any reason. It means the same thing. So we have to deal with each of these matters according to me completely and separately. So the first thing I think you need to do is when somebody is filing a case, right, and saying, this is my right. Where from Canada are you, right? That's what you counsel. Right? Constitutional right or statutory right, it can't be any other right or customary right. Where else the right flows from? Tell me. The word law, LAW. Law comes from, what are the sources of law? Legislation, customs. Come on. more active participation? The younger ones. Conventions. Okay, let's do conventions. How many of us agree about conventions? It's a law. What is convention according to you?
Practice.
Be more clear.
For example, there is no certain law or specific rules with regard to something, but that is being followed, and that is.
You're taking me towards customs now. It is good that you're thinking. Yes. Now that you provoked it, we are discussing convention and usage. I want to stick to these words.
Where the custom ends, then the usage starts. Where there is no customs.
You are there but not there, kind of feeling. I know it but I don't know. You know, yeah, but you're going the right way. Absolutely correct. These words are there, isn't it?
We're not getting the sense of there.
Conventions, usage, what is there? What else is there? Customs, conventions, usage. What?
Religion.
What else? Come on. I'm sure you've read it. Usage, convention, judgment law. No, but we are more on convention and usage. Can anybody go further than the word convention and usage? That side of the border. I'm provoking thoughts from that side. I think the first is us, isn't it? That side? Yes. I can see my hand going all over the place. Who is D? Huh? Civil judge become D. Any thoughts on that side?
Lordship, on usage?
Yes. The two words used, convention and usage. I asked the question whether, what are the sources of law? And the answer came customs, then usage and convention. So we want to have more clarity on these two words.
Lordship, I think it's a kind of tradition which has followed for a long period of time, which assumes the nature of law.
So how do we then prove this? If one was to prove it in a court of law, if you were a lawyer, then how would you place your case? If you are relying upon a right from a usage.
That particular tradition has been followed for a long period of time by a particular committee, or maybe from the previous agreements between members of the community. Okay.
But how would that be different from customs then? If you are basing it on a particular community.
Usage may or may not be rooted to the sensibilities or the actual rules of the traditions of the customs of a particular community, but it may, I'm not sure, Lordship. I think the difference between the two is very fine. Would depend upon the facts and circumstances of the case, I guess.
Okay, the second question. How many of us out here would agree that we don't have adequate knowledge about these two, usage and convention, which has been spoken of by the young judge here? I think there is therefore a need to learn more, isn't it? So let's learn more. understand usage and custom. Let's keep it for another session where all of you will give me a lecture on usage and convention. That'll be nice. I want to learn also. Senior most. You don't know? I want to know what is usage, what is customs. I can see your hand going on. Are you going to explain? Are you going to explain? Okay. Sorry? As usage. Use, the word usage comes from use.
It's first usage and then convention and then custom. It's like interconnected, one evolving after another. So usage then turns into a convention and the convention turns into a proper custom.
That sounds very logical. You're the closest, I think. Among all of us ignorant people, you seem to be very close to where we want to go. But let's learn more. Let's learn more. Let's do a little more research and understand this better. Because this is the area we are lacking in our jurisdiction. To interpret the law which is written, it's every judge will do. We will interpret. What is in the draft? Yes. Yes.
I read somewhere we say that custom starts where the usage ends. I was forgetting the sentence. Basically, all the people are practicing certain practices, and when that becomes very frequent, usage stops and the custom starts. That we would tell it as a custom. So
will it be right that, let's take for example a situation where I've been doing it for a long period of time, and this my doing over a long period of time is followed by him, is followed by him, is followed by her, and followed by you, and then it becomes a community usage. Does that become a custom? That's what you're saying. All of you shaking hands. It sounds logical, isn't it? Then what happens to convention?
Convention is logical. Now that I think about it, convention is when
You're the brightest among all of us. Yes.
Yes,
You sound more logical than all of us. Then.
Convention is when there is an agreement that this should be followed. For example, if there are two parties and we agree.
Just Google the word convention. Google the word convention. Convention is agreement. Now we're thinking. I'm so glad we have started thinking.
So here it says,
Even German is talking, which is very good.
an agreement between states covering particular matters, especially one less formal.
Sorry, sir, come again.
An agreement between states covering particular matters, especially one less formal than a treaty.
So there you are. So a little bit of discussion
So
is
that
helping
is
us
something, but
get there.
always it has to be prior to usage.
How?
Convention of an agreement with something first, then a usage.
But then if there was an agreement, then the Contract Act will rule, isn't it?
Conventions are generally used when two countries.
That's a statutory law, isn't it? When we talk about agreement, that will be the Contract Act. So we are talking about a non-contract situation, non-statutory situation. Usage, convention, this is a very oft kind of phrase. Usage, customs, what? Convention and customs, treaties. There is a very interesting set of articles by Justice Bhattacharjee in this Journal of 77-78, Sikkim Law Journal. Please read. Justice A. Bhattacharjee has written, he's written a whole lot of articles based in his knowledge about Sikkim. And you must understand his situation. At that time, there were not many lawyers appearing in the courts. Hardly any lawyers appearing before the High Court. Many of his judgments which he has rendered being the petitioner as well as the respondent. And creating his own issues and deciding the issues himself. If you read many of his judgments, you will find that kind of thing. Yeah. Many of the judgments he names the respective counsel, but if you go further into the judgment, you will realize he has created these issues himself. It does not come from the lawyers. You see, that was that time. We have gone much further. We need to improve. I think there is a need and a deep need to learn more about this aspect of our knowledge and brighten ourselves next time we meet them so that we are more articulate and discuss these issues further, isn't it? But now let's get back to this. We are supposed to deal with what? Land revenue and land management system in Sikkim. And what was the articulation before this? In the first session? Yes. So what was the knowledge that you gathered?
Earlier we used to use that tabletop, and now the GPS system has started with new land revenue or revenue survey, land survey. They're doing it through GPS. Earlier there was more use of tools, and manually was also done.
So the method of doing surveys were informed to you. Did he also tell you about how, under what law he did this? He had no knowledge. There's a lack of coherence there, you understand? I'll give you a little background about Sikkim's history. As I told you, my knowledge came from my father. He kept on this word Potapunu as for a long time I didn't understand this concept of Potapunu. But I start everything by Potapunu because it has been registered in my head because my dad came back in 1950s. And much of our survey and settlement was done under that law. This was my understanding for a long period of time. In many occasions, I had the occasion to discuss with my younger colleagues at the bar, and I relayed this knowledge, and I shared this knowledge over a period of time to all of them. But then in 2016, when the Chief Justice, created this committee to start this museum within a month, I had occasion to look at what documents. There in that I realized that in 1889 when J.C. White came in, and thereafter who was the next political officer, I keep forgetting his name, he also, both of them went around Sikkim. Because they were political officers, they surveyed Sikkim, and at different places, you must have heard the grievance of the people, and even at that time, there is no law which permits it, but by, I think, executive directions, oral or otherwise, I do not know, but parchas were prepared. I had occasion to go into the records of our High Court. Our High Court record has the records of the Magistrates Court. At that time, it has the record of the Chief Court. It has the record of the Diwan's Court. It has the record of the erstwhile High Court of Judicature at Gangtok. And it also has the record of the tribunals, special tribunals created by the proclamation of 1955, which created the High Court. And I was looking at these documents, I think we discussed it also, if you remember. Many of these cases dealt with parchas and Khatiyan much prior to the 54 or 52, whatever, the Kotapunu rules. So it seems in Sikkim, when the political officers came, the process of survey happened, whether quite clear that there were no laws there, but then the law made by the master was the law of the land, and therefore they were done. Many of them were, issued parchas. I found that my own, in a case involving my own, granduncle, I found his original parcha in that, in that, regarding this, what is that? Central Pandav land. You understand? And much prior to 1954. But that is history. In 50s, the king thought and realized that he had allowed a lot of settlement across the state. There were a lot of settlers in the state, but he was not getting the revenue. So for the purpose of revenue collection, the Kotapunu rules were prepared. It was squarely and precisely the record of rights. You know the difference between a record of right and a transfer of property. Do you know? Is Khatiyan akin to a sale deed? One is a transfer of property, the sale deed. When you see a sale deed, what do you see? A sale deed is two important things. What is it? What are the important things of sale deed? There must be a transfer from one person to the other. Therefore signed by both the parties, isn't it? Registered according to the law. As against that, a Khatiyan is basically the record prepared by the revenue officer. What is a revenue officer? What is the word revenue? What is the meaning of the word revenue? Tax, yes, closest. Revenue. Paisa will count. Paisa collection. Income. Revenue. That's right. So it was a revenue officer who were making the Khatiyan. This is called the record of right. Why is it called the record of right? It is called a record of right to record the rights of the parties from whom tax will be collected. The purpose of record of right is to record the name of the owners so that you could collect the. But have you ever given a thought to the parchas most of you hold? In that parcha, do you see yourself reflected as the owner of the property? बस्ती वाला मरि गएर किन्नुहुन्छ लाखौँ रुपियाँ चाहिँ त्यहाँदेखि बस्तीवाला हुनुहुन्छ है But in Sikkim we prize this more. The parcha is the most vital document. Every file I see in the civil suits, the sale deed is crumpled piece of paper. कहाँबाट निकालेको फाइलबाट मुस्किलले निकालेको, not filed at the first occasion, but on the second occasion, right? Torn, tattered, all sellotape लगाएको, and the parcha nicely laminated, perfectly intact. The one which gives you the ownership and title, you know, one who calls you the basti wala, you protect and fight for that. Why I am saying this is you must understand the distinction between transfer of property and record of rights. One is just recording your rights for the purpose of revenue collection. The other one is giving you the property, transferring that property. Right? This distinction you must know and keep it very clear. As a lawyer, I had the occasion to argue a case in which I pleaded before the High Court, much to my dismay not held in my favor, but not held otherwise also, reserved for another occasion. But I argued that the record of rights in Sikkim is much like a transfer. The reason I argued that was I felt that in Sikkim, all properties, and that's what we've been told, at one time all properties was of the Chokyat. How did we then get title? Right now, as today, as me, I purchased it, or me, I inherited it. But then, how did my father inherit? And how did my grandfather inherit? But if you go back, then you go back to a time that the old properties are owned by, right? If the Chokyal then did not transfer it to you by way of a conventional sale deed or a grant, many of the lands have been given as grants. That's also an absolute transfer, isn't it? Or for a particular, almost like a lease, right? But otherwise, the transfer has happened over a period of time through the Khatiyan purchase. So my argument was that therefore the purchase have attained the level of a transfer. It was not agreed upon. That is how I thought it was. But as of now, number of judgments of Supreme Court, it's record of rights. You know, there is one judgment of Justice M. Bhattacharjee, which says that in a case based in Sikkim also, that maybe in Sikkim, like in erstwhile state or whatever, some other place, it is so that the record of right is a transfer of property, but because of lack of evidence, I will not go into it and keep it for another occasion. When I argued, again the High Court also kept it for another occasion. On that occasion, when it will come, I do not know, because the evidence is not being laid. That is what is happening. You know? If evidence was laid in the suits that are coming before you, maybe there would be an occasion at one time to hold that what I felt was correct. But then I'm this side, there is nobody that side thinking like me. So I don't know what it will happen. You know? But getting back to the topic, it is record of right is a very distinct and completely different jurisdiction. It is only for revenue purposes. The law as it stands today for the whole of India is if there is a dispute between the record of rights and transfer of property, then it is the transfer of property which will have value than the record of rights. But the record of rights under section 35, I think, of the Evidence Act has a presumptive value that what is recorded therein is correct, unless disproved. So the record is, however, of the Bastiwala. That is, as far as Sikkim is concerned. This is a question again I'm asking myself. In I don't know other jurisdiction, whether it is recorded as the owner. In our purchase, have we seen it as the owner? I haven't seen it. I don't see the word owner anywhere. तपाईँले देख्नु भएको छ आफ्नो पर्चामा कुनै पर्चामा तपाईँको नाम चाहिँ ओनर भनेर यतापट्टि लेखेको छ बस्तीवालाको कलममा बस्तीवाला अन्त रिमार्क्स कलममा त्यहाँनिर के अरे किरायदार छ कुनै के छ कब्जादार छ त्यस्तोहरू हुन्छ कतै पनि ओनरसिपको कुरै गरेको हुँदैन. So even if what the Supreme Court is saying in so many judgments is true with regard to Hyderabad or somewhere else, there will be no occasion to compare these two parchas and deal with it correctly. There is not even a mention of our parchas in our parchas that we are the owners of it. It's just food to think. But for the younger ones, it is, you must have some clarity. Don't equate the two together. It comes in two different things. Simple logic is in the parchas, no? Who prepares the parcha? If you know. For that you have to read the earlier Kotapurnu rules for all the parchas prepared prior to 1988 and after 98. Presumption is, since the law exists, it was prepared under this, right? So therefore, it is the revenue officers who are making the entry. So think that you purchase a property today and I am the revenue officer, right? You purchase the property and I am the revenue officer, right? You therefore have your sale deed and then thereafter you want to correct the record of rights. So you come to the revenue officer, that's me, and you ask me to prepare the parcha and make the parcha and give it to you. Right? Mr. Srijan Bhoya turned into a judge. He's a smarter one now. He comes to me and says that I'm giving you this much money. Okay? That property which is in your name, transfer it into my name. He comes, I look at good amount of money and put it in my pocket. And I do it. It does not have the signature. It does not have the signature of the seller also. The document is prepared only by me. I can change it how many times? So understand the value of that sale deed. The sale deed must be executed before the officer, signed by both the parties, registered, payment of everything has to be done in a certain revenue stamps have to be. You understand? So the one is under the Transfer of Property Act, the other one is under the Record of Rights. Earlier was the Kotapurnu rules, now it is the 88 rules. If you understand this, I think you will not falter. But you have to be very clear. Most of the civil suits, and I'm sure the senior judges will agree with me, is based on parcha claims. 99%, would I be wrong to say 99% is based on parcha claims? In such situation also, you should also ask, maybe some of them will bring out the sale deed. It's all at the area 5 now. You might get a sale. Because you are basing your entire judgment of title on a presumptive document. It just gives you a presumption. Is there anything that we need to discuss? Tired of. Then we call it a day, I think. Quite tired. Huh? Dead tired should be the word. Yes. Anything else? And what is Bhutia? That's interesting. Kotapurnu. Kota Purnu. That's why it's registered. What is the meaning of this Kota?